Hello, hello, hello. It's me again, the snarky juror, returning for the afternoon of day 4 in the Florida trial, Florida versus Ashley Benefield, in the death of Doug Benefield. Surprisingly to me, Miss Ashley took the stand this morning. She was the second witness for defense. And it was pretty emotional, at least for me. I don't know how the jury received it, but it was emotional for me and for her. They broke for lunch, and we will pick it up with, I'm assuming, with the cross-examination by the prosecution. So let's go ahead and cue this up and see where we're at. No, not you, sweetheart. Leave closed captions on. Let me check and make sure I'm in the corner. Yes. And my mic is hot. Yes.
Because my
when I was queuing it up, the judge was saying something, so I kind of backed it up. I didn't know how far back to go. I don't envy her at all. They have put her back in that headspace that she used to live in.
I take my own photo. I need to show them some things. Can I take my own photo?
Yeah, let me know if you find everybody.
Okay.
Obviously, they're not ready to go yet.
About 1:08 in the afternoon. I have both prosecutors. In the afternoon, we're back on Ashley Benefield. We've had our lunch break. It's about 1:08 in the afternoon. I have both prosecutors and Mr. Taylor here along with Miss Benefield. Before we get started, Miss Benefield, when we took our lunch break, I gave you the full warning that I give to all the witnesses that you've heard multiple times regarding sequestration. I was erroneous, however, because my instruction to the criminal defendant has to be modified slightly. You are allowed to meet and speak with your attorney over the break. I no sooner got upstairs than realized I gave you the full sequestration instruction. Now, there was no objection to it. Case law talks about if there's an objection to it or a deprivation of the right to counsel. But I want to make sure if there was any error, or even arguable error, that I correct that now.
I appreciate it, Judge. We'll be able to get it all worked out.
Okay, so I'm happy if you want to take time to speak because you're allowed to. I'm happy to take a recess and give you that time if you need.
Thank you. We're fine.
All right, sir.
I think there will be a pre-objection to something I intend to introduce. So.
Okay, yeah, if you know about them now, let's talk about them before we bring the jury in.
And why bring it in? Have
But I don't know which ones it- You would check.
All right. Oh, you don't have to approach. Or unless you want to. Is it something we want to keep?
No,
Okay.
It's her fault if she walked first.
I did.
So I have States Exhibit 103 and States Exhibit 104.
Yes. It's their objection, so.
Okay. Yes. Objection.
Relevance is to the modeling photo, and mugshot, we submitted a memorandum to the court. It's pretty clear case law, mugshots are not.
I disagree that the case law is clear, the mugshot is not admissible. But the relevance of both of those is to show her face before and after this incident, so the jury can make their own determination if there's swelling on her face. And I did say when we had a pre-trial discussion about the mugshot that I would not intend to enter it unless the defendant made it relevant by testifying that she had swelling on her face. So I do believe now that she said there was swelling on her face, I can introduce the mugshot of her weeks later to show.
I apologize.
I was done, I'm sorry.
Objecting party, rebuttal.
I know I wasn't able to introduce in the state's case in chief. I don't think they should be entitled to introduce at ours either.
Well, I think there was some evidence that was introduced. It all depended on what it was. Thank you both very much. 103, what did you refer that to? A modeling picture? Is a modeling picture showing the defendant's front face and down to the chest area. And 104 is, I've not compared it, but you say that's the booking photo that was taken when she was arrested. All right, I was just checking because there's like a speck on it. I was checking to see if that was a paper speck or in the picture. So yes, what we originally talked about, I don't agree that there's a blanket prohibition on the entry of a booking photo. However,
it's prejudicial, I think.
it is a bit of a more unique situation if there was an erroneous decision not to allow one party or the other to introduce evidence during the other side's case in chief. It's a fairly simple remedy that the other party can just call them in their case in chief or in rebuttal, lay the proper predicate and introduce the evidence if it's admissible. In this situation, it's a little bit different, obviously. These would need to be authenticated by the defendant, so I don't think it's improper. I'll allow it. The only thing I'm going to require, however, is the 104 is just to be referred to by the date. On such and such a date was your photo taken.
And Judge, I respectfully disagree. There's no case law that says a jury cannot know that a person was arrested. The only case law is that a person cannot be made to sit at a trial in jail clothes. But there is no prohibition. They know she was arrested.
Mm-hmm.
So I believe that helps substantiate the date that it was taken and the time that it was taken.
And I think you can ask her the date and time. So, yeah, no, overruled.
All right, can I see the exhibits?
Of course.
Judge, just for the record, the state has still not received the ordered defense exhibit list that we instructed them to get.
Are there any other defense exhibits? Well, let me, let's close this issue out.
Yes, sir, I'm sorry.
All right, so defense has handed state 103 and 104 back. The question was asked regarding defense exhibits I don't know what's left. I don't know what witnesses are being called or when. But do you have an exhibit list that complies with Rule 3.220?
I think we gave them all.
No?
Judge, they gave us 360-something items, file folders with multiple pages in each one. That does not comport with the rule. They need to tell us what they are going to introduce specifically.
Well, the rule calls for what do you intend to introduce?
We have them, we'll share them with the prosecution today.
Prior to any other witnesses being called?
Yes.
Okay. Are you ready? State.
Judge, I just still would ask for a list because it's hard for us to, when showing us them, I don't have the ability to recopy them and do all those things like I would have if I'd gotten a proper list. And so it's just hard for me to be able to then go find the things to be able to figure out if they're complete.
So here's what we're going to do. We're going to have a mid-trial exhibit exchange. And we'll take a break. Maybe it'll be the mid-afternoon break. I have no idea.
We'll give them a list.
And you're going to get a list. And if not, you can go through them and you can write on a piece of paper exactly what they are. And if you say, I want a copy, they're going to give you a copy.
Yes, sir. Thank you so much.
Okay. Problem solved. You ready? You ready to go?
Yes.
All right. When we finish, Ms. Benefield, you were on the stand. So if you could reposition yourself, please.
And if we could put the screen down, please. And shut the blinds. Thank you.
Yeah. The clerk is going to leave the lights. The clerk's going to leave the lights as is. When you need the lights lowered, then let us know.
Okay. What number is that? I don't know what you're talking about. 52. I don't need it. Oh.
All right, bring in the jury.
I'm sitting on Canada Dry, so if I burp, excuse me.
Or you all can have a seat. Welcome back, everybody. Over the lunch break, did anybody talk amongst yourselves or discuss the case in any way? Did anybody talk with anybody outside of the jury about the case? Or did anybody do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
Everybody says no. Well, State, you may begin your cross-examination.
I would like to just start with a couple of issues. So first, Doug Benefield never punched you, ever, correct?
Yeah, I'd say that's correct.
Doug Benefield never choked you, ever.
No,
He never kicked you.
no.
He never pointed a gun at you,
He waved a gun in my direction.
but it was not pointed at you,
It
correct?
was pointed at me while he was waving it at me.
He never came at you with a knife
No,
or a club
no,
or a baseball bat.
no.
So there are 30 years difference between you and Doug, correct?
Yes,
And you got married after 13 days.
yes,
And you spoke with him about, or organized with him about starting this ballet.
yes,
Correct. And all of the money for the ballet came from him or investors, right?
my mom also funded the part of the ballet.
You didn't put anything into it. Money.
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No,
He didn't.
he did not pay for the cruise. No.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go. So
Okay. So he paid for your friend to go,
yes.
and he did not go with you.
Oh no. Mm-mm.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. And I have the entirety of it on a spreadsheet that I'm going to put up, which is State's Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, state would enter into evidence State's 99.
Did you want to be heard in addition to what we said earlier?
I haven't actually seen the specific message.
Well, she can pull fast ones, but he can't. Got it.
Any objection to State's 99? Received.
So I'm going to put this up on the board behind you, screen. We're trying to get it to come up on the screen.
I wish they quit whispering. It's rude.
Okay. So I would like to orient you to what we're looking at. So on the top line, it gives whether the messages are outgoing or incoming. That would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
Okay. So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. Oh. My ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. Like always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug. Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen.
Where?
That's September 1st, 9/1 something. It's pretty damn elegant.
So yes, my love, I think was the last thing you said. And then what's the next thing?
Are you doing things that are dangerous?
And you're gonna have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip.
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. Then a rectangle. It makes me so sad. And then another rectangle. If I dwelt on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself. You were easy prey for predators. You're sweet and want to please people, and they used that.
And you said, I'm sorry, and then he said,
I desire to exterminate them, and holding back is a challenge. They are rats that should be removed.
and you said,
Oh, baby, my love. Yes. Like that night, like last night, just the jerks arguing near you about put me in a sheer murderous mood that I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, but could have been a fight, etc. Only you being with me will over time remove images in my head. It is same, and knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but
can you pull that back up?
he said it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad, I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
No.
I guess you could put it that way.
Okay. You can continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person with your legs spread and a shitty person choking you out. That haunts me. I love you and I never want to hurt you. I'm sorry. Oh, rectangle. Now all I see is some douchebag on top of you, fucking you with your legs spread and him choking you out and fucking you more. Right now, I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband who is gentle to me and kind. He said, we went from joy and passion to now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
So this conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had had with him explaining that this had happened.
I think he was referring to on the cruise one night. I was talking to him on the phone and I was sitting out in the hallway up at the top deck and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were
I'm
talking,
gonna stop you
he
there.
heard.
Is the answer yes or no?
She's saying,
He needs to allow her to finish her answer, Your Honor.
you finish your answer.
He had heard a couple guys that were talking loudly and he got upset because he thought these guys were going to hurt me. And so he had talked about then that he imagined that, you know, I was out in the world without him and that people were going to take advantage of me and that he didn't know what was going to happen to me.
And he was afraid for your safety.
Yeah.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him into a rage.
Yes.
And that scared you.
I'm sorry.
And that scared you.
Well,
That time.
as I said earlier, at the time, I kind of, you know, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, you know, manly.
Okay.
Trying to put
So-
words in her mouth.
I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that.
Part of it went on my debit card or my credit card.
And your intention was to get pregnant.
Yes, we had talked about that. Yeah.
And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April. 7.
And was this during this time? You said he had started criticizing you, right?
Mm-hmm.
About the way you looked, your clothes, the way you acted. He was, according to you, he flipped a table, tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore,
Yes.
and you want a baby.
I mean, Yeah, we were married. We wanted a family.
Okay. So the vasectomy reversal happens, and I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then. You know,
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy.
The doctor had told us that it probably wouldn't work for a while, so it wasn't something that we thought would happen that fast.
Okay. But it did.
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a wall,
He threw it at me.
shot a gun at the ceiling. I think you made several allegations, correct?
Yeah, he admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that
Okay.
were not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
9 years.
10 years. 9 years, 10 years.
And this tension surprised you.
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own.
Oh, I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture that had like deep sides and like the glass was at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote a saying on it that said something about how like you can be strong through the storms and that, you know, seashells are beautiful things that come out of storms.
And that shadow box is the reason you were arguing that day with Doug, correct?
I know it came up at one point. I don't know if that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad. I had taken a lot of time to make it for her and I thought it was special. And yeah.
You began crying.
Yes.
And you dropped to the floor and sobbed hysterically.
Probably.
You were so upset that she put her dead mother's rose in the shadow box.
It wasn't that. It was that she took it apart. I mean, I would have bought her another shadow box.
You went to Doug and said it was disrespectful that she took this apart.
According to Doug?
No, according to you. You went to
Okay.
Doug and said, she's acting disrespectfully. You need to handle her. She upset me. I'm crying.
I don't remember saying that about that.
Isn't it, in fact, what you were arguing about before this whole incident with the gun and the ceiling?
Is this relevant as it relates to the daughter?
Can you approach, please?
You quit putting words in her mouth. Do you want to testify or do you want her to? Snarky in the bad way. and you did this, and then you did that, didn't you?
So the day that this argument happened, you actually, at one point, were in the car with Doug, right?
Yes,
Okay, you were going to the bank and going to do some other errands.
I believe so.
And the entire time, you're upset about this shadow box.
I don't distinctly remember that, but the argument kind of came from there, I guess.
And in fact, it wasn't an argument, right? It was you being upset.
Well, he said that like life was out of control and he couldn't deal with the people at home and he couldn't deal with the people at the ballet. And he felt like everything was just too stressful and he was upset with everybody.
And didn't he ask you to stop?
I'm sure at some point.
And you didn't stop
I guess not.
for the car ride? No? Yes or no?
I don't remember.
And you kept telling him you need to discipline Eva.
I don't remember saying that.
Okay. And he said, let's just stop talking about this for a while. I need to think.
He was yelling at me.
So he's yelling at you, but you weren't sitting there like you are now, were you? You weren't sitting there like this.
I guess I was buckled into the car, so I probably would have been sitting further back.
And you didn't stop. And then you get home, you're still arguing.
How does
correct?
she know this?
He was still yelling at me, yes.
And you're not yelling at all. And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house, correct?
I'm not sure why he had it, I guess.
Okay. And it was in a holster.
I believe so.
And you both used to carry guns.
Mhm.
You carried guns on a regular basis.
Yes,
you
ma'am.
have had at the time more than one gun.
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis.
I haven't been to their range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra.
Yes, that's where I concealed carried.
Okay. So having a firearm in a car or in the house is not that unusual to you.
No, ma'am.
All right. So after you get back inside, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva.
I don't recall that.
How does she know? Was she
And you
there?
say he was waving a gun around and threw a gun at you. Is that what you said?
Yes, ma'am.
So he has a gun in his hand, could point it at you,
He did point
but
it
he
at me.
throws a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall.
Yes, ma'am.
Okay. When was this? What was the date of this argument?
I believe it was the end of June.
2017.
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you'd been married before, you were now having a wedding reception.
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come.
I'd say maybe a dozen. My friends and family came.
And they're dressed up.
Yes,
You're in your wedding dress.
yes.
Okay. And I'm going to show you State's Exhibit 10. I want you to tell me what this is. Or I'm sorry, it's 100. I want you to tell me what this is. It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is it at the same wedding reception?
Yes.
And State's Exhibit 102, what is that?
It's a picture of my friend Laura and me, and then my friend Christy.
And this is also at the same reception?
Yes, ma'am.
State will move into evidence states 100 through 102.
Any objection?
I'm sorry, I missed it.
Any objection to states
No.
100, 101, 102?
No.
Received.
Thank you. And in states 100, are you scared here of Doug?
No, I would not say no.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh, no, not at that moment, no. That was a very nice day.
How about at this moment?
Oh, it was a good day.
And states 102 at this moment?
Same. It was a good day.
What do you think keeps people hanging on? Oh, we had a good day. Maybe this will continue.
So you
Oh,
get pregnant
Scott,
and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay, but going to your mom's house was your choice, right?
We decided together. He said he couldn't take care of me. He was too busy, and that my mom could take care of me better. So I was happy to
And you
go.
needed someone to take care of you while you were pregnant.
I was really sick, yes.
So you moved down with your mother at maybe August of 2017, you said?
The end of August, I believe.
Okay. But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina, Florida thing, correct?
no.
I'm not sure I understand the
Well,
question.
you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So shortly
November.
after you move in with your mother, a couple of months, you file for an injunction in South Carolina.
Yes, ma'am.
And we talked about the fact that, or you talked with the defense about the fact that it was a mutual injunction.
Yes, ma'am.
So both parties agreed to stay away from each other, correct?
Yeah, I believe that it was for both parties to stay away.
No evidence was presented at this hearing.
I don't believe so.
None of your complaints were heard at this hearing.
There was like a written, like a filing.
But the judge, other than that, did not hear any evidence at the hearing.
Other than
That's
that,
correct.
All of that was forestalled because the two of you agreed, okay, fine, we will have this voluntary stay away order.
It was decided through the attorneys, but I believe that was, yes.
Okay.
Yes, ma'am.
So the judge never found that Doug Benefield was dangerous and ordered this injunction.
I'm not sure what the judge found. I don't know what you mean by that.
There was never a court finding giving you an injunction other than you stipulated to it.
The judge ordered it. Yes, ma'am.
Okay. And this injunction, actually, part of it says that neither party shall harass or threaten or do those types of things to each other,
Yes,
right?
ma'am.
Okay. So then after you're in Florida, you get a package that you say was in violation of this injunction. And it's a birthday present, right?
Yes,
It's a tea set,
among other things. Yes, ma'am.
and you liked tea.
I like drinking tea. Yes, ma'am.
You drank tea all the time with Doug.
Yes.
Okay. And you opened this tea and you claim that it smelled so strongly that you automatically rushed it to the sheriff's office.
excuse me.
I didn't specifically sniff the tea. It was when I opened the box, the whole, like, contents had a very strong chemical smell.
So you immediately rushed it over to the sheriff's office.
No, ma'am. I immediately sealed it up and I left it in my garage.
For how long?
I don't remember specifically. It was like maybe a day or two. I don't remember.
It was a little bit longer than a day or two, was it not?
I don't remember.
So after this time goes by, you take it to the sheriff's office and you claim that this was a violation of injunction. Right.
It was, yes, ma'am.
And you also claim that this was all part of Doug's poisoning scheme to poison you and your unborn child.
Hazmat informed me that there was toxic
I don't want to hear what
chemicals
someone else told you. I want to hear what you claimed, that this was part of his poisoning of you, plan to poison you.
Well, based off of what I was told, that was the
Yes
conclusion
or
I came
no,
to.
ma'am? Yes or no? What, according to the way you felt, this gift was a part of his plan to poison you.
It concerned me. Yes,
Okay.
ma'am.
So no charges were filed for that, correct?
Correct.
So you filed for an injunction based on the same allegations, right?
When my injunction in South Carolina was getting ready to expire, yes, I filed for one in Florida.
Okay. So when you filed in Florida, about what time was this? What date?
I could give you a ballpark. It was in the spring. I don't remember exactly
Spring of 2018?
Yes, ma'am.
Okay. So you had left Doug in South Carolina August of 2017,
Yes, ma'am.
and you filed for an injunction in the spring of 2018,
That sounds right.
but you hadn't been living with him, correct?
Correct.
You hadn't even had any contact with him for a very long time when you filed for that injunction, right?
Well, other than him sending the box and
Okay. So what violence were you trying to prohibit by filing this injunction? Everything that happened in South Carolina.
well, I was just hoping that wouldn't happen again.
Okay. And at the same time you did this motion for an injunction, you also did a motion to terminate Doug's parental rights, right?
Yes, ma'am.
Okay. So during this time that you haven't been with him in almost a year, at least half a year, there hasn't been any violence other than you say the T said. You're filing for an injunction all at the same time that you're trying to terminate his parental rights. This is all correct, right?
Sounds correct, I
Okay.
believe.
And you hadn't even had the baby yet.
As of when?
As of the time that you were trying to terminate his parental rights.
I don't remember what the date was, but it would have all been around that time.
And then there's the hearing that goes on for this injunction, right? And this is in front of Judge Moreland, correct?
Yes, ma'am.
Okay. And you had a 2-day hearing on this.
Yes, ma'am.
Partially, it was a motion for your injunction based on these issues, and it was also Doug's motion to be able to see his child, right?
I believe at some point things got consolidated, but I don't recall specifically.
So at this point, Doug had not seen his daughter.
Correct.
And your daughter was how old?
As of the date, like the last court date,
Yes.
about 6 months old.
And had there been any violence towards you between the time that you filed for this and the time when you had the hearing and she was 6 months old?
He had showed up at night in my driveway, but I mean, there's no physical contact if that's what you're asking.
Okay. And was this a time when the baby had been born?
I don't remember the date of when he was in the driveway.
How about, since we're talking about this, let's talk about the incident you talked about where the neighbor said that that Doug was there. Can you tell me about that?
Yes, ma'am. He was outside standing in the yard at night, I guess trying to look in the windows of my house.
And where's this neighbor's house?
She is directly across the street.
Okay. And isn't it true, in fact, that this was very dark? It was very dark out.
Yes, ma'am, it was at night.
Okay. And your neighbor told you that she saw someone in her backyard walking, correct?
I think she said that when she confronted him, he kind of ran away.
She never told you he was at your window.
What she said was that he was trying to look in the windows.
In her yard.
The way the houses are situated, where he was standing, he was looking across into the windows of our house. Yes, ma'am.
And she couldn't see who this person was.
Object.
She told you.
She's asking Ms. Benefield about what the neighbor knew.
Overruled.
She told you she could not identify this person.
She said by just looking, as dark as it was, she had a hard time identifying him by his face, but that she identified his voice.
That's interesting. So let's talk about that. So when she tells you that there's somebody in her backyard, you go to her house, right? You end up together with her.
Yes.
All right.
Not at her house, but yes.
And you play a recording that you've recorded, like a voicemail from Doug for her, right?
She believed it was Doug, and she said that she could probably identify his voice because he had a unique voice. And so I played a voicemail I had from him, and she identified him.
The fact is,
from
she
that.
didn't tell you she thought it was Doug. You just asked her if it was Doug.
I believe she contacted us and said that there was a strange man looking across into our windows, and she was freaked out, and she wasn't sure if it was him.
Okay.
I don't remember specifically. I'm sorry, this is a long time ago.
And you play a recording of Doug's voice for her.
Yes, ma'am.
And she goes, oh, that's him.
Yes,
That's
ma'am.
the one that was there.
Yes, ma'am.
So that is the ID that Doug was in her backyard.
I believe she also described his body type, his stature. She said he was wearing a baseball cap, which he often did. So I think that was probably
Don't a
part
lot
of
of
it.
people wear baseball caps?
But she needs to allow Ms.
I'm
Benefield
sure.
for your answer before she cuts her off.
I've been able to follow along, so I'm overruled at this point.
Oh, come on, Judge.
There's a lot of people that are 5'9", right?
Oh, yes, ma'am.
A lot of people that weigh 160 pounds.
Yes, ma'am.
A lot of people that wear baseball hats.
Yes, ma'am.
And isn't it true that this person in the backyard said to her, I live around here. I live here.
Hmm.
Okay,
I believe so. I wasn't there for that part, but that's what I believe she told me.
thank you.
Yeah.
Now I want to move forward to 2019.
I want her to shut up.
Around this time, Judge Moreland had already ruled that you could not have your injunction, right?
She denied it. Yes, ma'am.
And that Doug could have immediate visitation with his daughter.
She ordered time sharing. Yes.
Did you start visitation with Doug and Emerson very shortly after that hearing?
Yes, according to the court order. Yes, ma'am.
And you decided you were going to go with him on this visitation?
I offered, and he said he would be glad for me to come. So yes, I went.
This person that you lived in a nightmare with, you decided to go with him on this visitation?
Yes.
To protect her daughter, ding dong.
Now, the Judge Moreland hearing, when she ruled, she made it very clear that she did not see your side.
Sustained.
You had no faith that Judge Moreland was going to help you from that day forward.
Overruled.
You had no faith that Judge Moreland was going to help you from that day forward.
I don't know. They'd say I thought she would never help me, but I mean, she denied the injunction. Yes.
So you go for this visitation with Doug, along with him and Emerson, and that begins sort of I think Stephanie Murphy called it like a honeymoon period or a happy period piece. Would you agree with that?
Yes, ma'am.
Okay. So during this time, you spent a lot of time with Doug
Yes.
and a lot of time with Emerson.
Yes.
And you weren't scared of Doug at that time?
He was being very kind.
Okay, so you weren't scared of him at that time?
No, I mean, I had things at the back of my mind, but he was being very kind.
So then around summer of 2019, you actually make arrangements with Doug. He's going to move into your mom's house.
He wanted to move in, yes.
You actually agreed to that.
Not specifically. He didn't really ask my opinion. He told me.
Okay. And then the date that he was supposed to move in, you made plans with him,
Hold on a
correct?
second. Sir, who's crinkling the paper? Is that Mr. O'Keefe? Sir, can you please stop? Thank you. Go ahead.
So during this time, you're speaking with Doug,
Yes.
right?
Yes.
And you're talking with him about moving into your home.
He was insistent that we needed to
The
move in
answer is
together.
yes or no, please. You were talking with him.
She interrupting the answer.
If the question calls for yes or no, the questioner has the right to expect a yes or no, or I don't know, or I don't recall,
So
as opposed to a narrative.
you were speaking with Doug about him moving into the house
Yes.
and about his things being moved and when they were going to be moved.
Yes, I'm sure.
And at any time during this, did you say to Doug, no, you're not moving in?
Yes.
You said no.
I'm sorry.
You told him, no, he cannot move in?
Yes, that's why he ultimately didn't move in, as I said,
Okay.
I can't do this.
Isn't it true that, in fact, you didn't tell him no, you just weren't available the day he was supposed to move in?
No, that's not correct.
Okay. So you're saying the day he was supposed to move in, he knew he wasn't supposed to move in? Is that what you're saying?
We had a conversation that day, and I told him that I didn't want him moving in.
Okay. And then you did not take his phone calls. You would not speak with him. I think the word was ghosting. You ghosted him.
I don't know whose word that is, but that's fine. Yes, ma'am.
Okay. But visitation continued.
Yes, ma'am.
All right. And you continued to exchange custody of Emerson where? The sheriff's office or?
I believe at that time we were doing the sheriff's office.
And sometime around this time, you show up to this visitation with an engagement ring on, right?
No, ma'am.
Okay. Who is Dennis Beatty?
Dennis Beatty.
Beatty. Who is that?
He was a gentleman I dated at one point.
And it was during this time that you were dating him, right?
After I told him not to move in, and then we started just doing time sharing with Emerson. Yes, after that, there was a period of time where we
Okay.
dated. Yes, ma'am.
And isn't it a fact that Doug filed for a divorce after one of these visitations?
I'm not sure when he filed for divorce specifically.
He filed for divorce after he knew that you were dating this other man, right?
Once again, I'm not sure when he filed.
How did he find out? Did you tell him you were dating him?
No, ma'am.
Right. How did he find out?
I think he was stalking me.
It wasn't the ring on your finger?
It was not an engagement ring. ma'am.
Well, it was a ring. Did he see the ring on your finger?
I'm not sure what he saw. I wear rings all the time.
So Doug files for divorce. And all of a sudden you file for, well, you start a bunch of complaints, correct? About his treatment of Emerson. What you say, his bad treatment of Emerson.
Well, she started coming home hurt.
It's a yes or no question. Did you file complaints about his treatment of Emerson?
Yes.
Okay. And you eventually filed for another petition to get an injunction based on those incidences that you claim happened with Emerson.
Yes, ma'am.
Okay. And you complained about the first time and nothing was done. Is that correct? With the police, no charges were filed, nothing was done?
I'm not sure specifically what you're referring to.
The first complaint that was made,
About,
Emerson and Doug, you agree that you made allegations.
Jack, can we,
Yes.
I hope the jury's feeling the same way I am. I'm ready to punch her in the face, the prosecutor. I'm climbing out of my skin over here. She is so offensive in her demeanor and how she's acting and the questions she's asking. How does she know all this crap?
During this time, did you speak with members of the sheriff's office?
I'm not sure specifically what time you're referring to.
During the time that there were allegations that Doug was abusing Emerson, did you speak to the sheriff's office?
Yes, ma'am.
On numerous occasions,
I would say so, yes.
at least 5.
Probably yes, ma'am.
And during those conversations, you were making allegations that Doug was abusing Emerson, right?
Well, I was explaining the injury she'd come home with. I mean, I wasn't there. I don't know what happened.
Okay, but you were alleging that Doug was abusing the child.
I was concerned after her pediatrician called CPS and said that she thought she was being abused.
Are you aware that pediatricians are required to call CPS when a mother alleges that?
I didn't allege anything. I brought a video to show her at the appointment, and she called
So you
CPS.
objection?
Finish your answer, ma'am.
Well, after showing her a video of some behavior, she called CPS and she informed me that I was also a mandatory reporter and that it would be negligent if I didn't also call and make a report.
You brought Emerson to the pediatrician specifically for this reason, correct?
No, ma'am, she had her checkup.
But you brought this up to the pediatrician.
At the end, she asked if either of us had any questions.
And that's when you bring up, oh, she must be being abused.
No, I described to her the behavior that I was seeing, and I showed her a video when she came to her own conclusions.
Okay. So you spoke to the sheriff's office about that investigation and other investigations, and about the investigations that Doug was abusing Emerson.
A sheriff usually comes out with the CPI from Child Protection.
And you spoke to them.
I mean, they were there when I was talking, I guess, yes.
And you were talking, making allegations against Doug, assuming that he caused injuries to Emerson.
I'm not sure of my exact words. I was trying to describe to them what I was seeing and my understanding of the situation at the time.
You filed a petition for an injunction based on those things, correct?
At the advice of my attorney, yes, ma'am.
Okay. Whether your attorney advised it or not, you chose to do that, correct?
Yes, I followed the advice of my attorney.
Yeah.
And you were aware that if you went forward on this injunction, that it was going to be in front of Judge Moreland.
Yes, ma'am.
And this injunction hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved.
Oh, so now she's going to switch from saying it was because of the report from the doctor that she decided to knock off her husband. Oh, now she's shifting it to this. I do not like her. Do not like her at all.
Hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved several times, but that was a date.
Okay,
Mhm.
so it was supposed to take place on that day,
Yes, ma'am.
and there were other things pending. Do you know what the other pending items were?
Not specifically.
Okay.
I'm not sure what you're asking.
One of them was Doug's request for a divorce, correct?
Yes, we both filed for divorce at that point. Yes.
So Mr. Benefield filed for divorce, you file an injunction petition, then you file for divorce.
I filed for divorce first.
Okay.
I believe.
And then you're scheduled to have this hearing on 9:30.
Yes, the hearing was scheduled for 9:30. Yes.
Well, the injunction,
And you're speaking with Doug during this time, right? I mean, we just
Yes.
heard
she has no
200
choice.
and whatever text messages between you and Doug.
Yes, ma'am.
So do you at any time in that say to him, I'm going to go forward with this injunction on Wednesday, on the 30th?
No, ma'am.
In fact, based on those text messages, you were dropping the petition for an injunction.
Yes, we talked about dropping everything. Yes.
No, you talked about it, but you said you were going to.
Yes, ma'am.
And that is what the result of the mediation was. That there was not going to be any mediation really because you were reconciling.
Yeah, we agreed, I guess, in order to move to Maryland. My understanding, the attorneys were advising us to, if we close things down, that it would make it easier, like legal wise, for us to relocate.
So you were telling Doug that's what you were going to do
Yes, we were trying to work things out so we could all go to Maryland. Yes.
and drop the injunction.
That was one of the things.
And you wanted him to drop everything, right? The motion to release the report, the dissolution of marriage, you wanted him to drop everything.
No, we filed a joint stipulation so we could get the report.
But then you asked him to drop that, didn't you?
I know we kind of went back and forth with so many things.
Okay. You never had any intention of not going forward on your injunction.
Honestly, it was kind of one of those things that some days I thought that maybe I should, and some days I thought that I shouldn't.
So during this 1 week before you shot Doug, you're talking and you're saying to him things like, oh, we're packing boxes, we're getting everything together. This whole time, you knew you weren't going to stop that injunction hearing.
I hadn't decided yet.
Okay. Your attorney testified that you were going forward on that injunction hearing.
She was advising me to keep it.
Okay. So during this time when you're telling Doug to bring different boxes, bring tape, you asked him to go to Selby Gardens, right?
Yes, we all went. I think we got lunch. We brought Emerson so she could play.
Okay. And you are having conflicted emotions about whether to go forward on an injunction
Yes, ma'am.
while you're out having these types of experiences with them.
Yeah, sometimes things are really good and other times they weren't.
Okay. And so how about, let's see.
It's about the music.
This is part of State's Exhibit 98.
I didn't know what it's doing. I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real?
Like a word.
Real?
Like working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum.
people literally
Oh, no, it's running out of time.
I live in
House.
a
Real house. White.
So put together.
Housewives of. Oh, really? Oh.
And this video was taken the week before you shot him, right?
I don't know the exact date.
When was, I mean, in your mind, it was very close to the time, correct?
Yeah, I'm sure it was right around then. I don't remember when it was.
And during this time that you were having these text messages with Doug and you're planning to move to Maryland, there's no violence going on.
No,
No,
I guess not. No,
he's not hitting you.
no, ma'am.
He's not choking you.
No, ma'am.
He's not shoving you around.
No, ma'am.
So this entire time, there is no violence going on.
I don't know specifically what time frame you're talking about. I'm sorry.
But during this, let's say from 2018 to 2019, when you're not living with them.
I mean, if you classify violence as him like
I'm asking
punching
if
me or
there's
choking
physical
me.
violence
I mean,
during this time.
he could be rough sometimes.
Okay.
Yeah.
Did he ever punch you?
Not during that time, no.
Did he ever hit you?
No, ma'am.
Did he ever use a weapon against you during that time?
Not during that time, no.
So in between the time of 2019 to 2020, where you shot him, was there any physical violence?
Like I said, sometimes he'd be a little rough, you know.
But other than that, he never was physically violent.
He didn't like punch holes in the walls or anything like that, no.
So when I asked you if has he been violent, you said, well, he didn't punch holes in the walls. Is that what you just said?
That's what I just said, yes, ma'am.
So punching a hole in a wall to you is a definition. When I ask, was he violent? Your definition of that is punching a hole in a wall.
I think that is violent.
Okay.
I'm not sure what you're asking.
So hang on just a second.
We have you back for when everything went.
So I want to get to the day that all of this happened. This happened on a Sunday, right?
Yes, ma'am.
And you're moving on, or you have a hearing on Wednesday,
I believe that's correct,
and
yes,
you're
ma'am.
moving right after that.
I think the actual day of move was kind of in flux. It seemed like it changed 1,000 times.
You're all getting in the car together, not together, but you're driving cars together to go to Maryland.
Yeah, I believe he was going to be driving the U-Haul and pulling his truck. And I think that my mom was driving her car and I was driving mine.
And you were telling him during that time that you were going to move to Maryland and attempt to reconcile.
No, ma'am.
You weren't telling him that.
No, not in those words, no.
Did you hear Dr. Broder testify about that? That he said that when you were with Doug,
Objection here.
Sustained.
so you're denying that you ever told Doug that you were wanting to reconcile with him.
I said I wanted to find a way that we could do things together as a family for Emerson's sake, you know, and that's why we started doing things differently. He wanted to move back in, you know, together, and I told him that I didn't want to do that. I didn't feel comfortable with that.
Did you say that in Dr. Broder's office in front of Doug?
No, not in front of him.
So when you're with a safe person, a psychologist, you're not telling Doug this.
What? I'm sorry.
You're saying that you told Doug when it was just the two of you that you didn't want to move in together.
Yes, ma'am.
And you felt safe telling him, I don't want to move in with you. Right? That's what you're saying.
Yes, we had that conversation many times. Yes.
But you're in front of this psychologist who one would think is a safe environment with Doug sitting next to you. You hear Doug say to Dr. Broder, we are going to Maryland and we are going to try and reconcile. and you don't feel safe enough to say to Dr. Broder, no, that's not what I want to do.
I would want to make him look bad in front of somebody else.
Okay.
I wasn't going to disagree with him in front of anybody.
Okay.
Because that could set him off too.
So the plan was to load up the truck, get everything done, and then move very shortly after the court hearing, right?
Yes, ma'am.
Okay. And you had no intention of dropping that injunction, so you knew on the day of that hearing, he was going to know, right?
I'm sorry.
You knew that Doug was going to know that you had no intention of reconciling with him.
We had the conversation many times. I think he understood where I was at.
Okay. You saw the text messages between you and him, right?
Yes, ma'am.
Would you agree that those text messages do not indicate that?
It doesn't say we're getting back together, moving in together.
It doesn't say we're not going to reconcile.
I mean, not specifically, no, I wasn't going to argue with him.
If you got your injunction on that day, September 30th, how would you have moved together?
Speculative.
Also saying,
What was your plan if that injunction was
Speculative.
granted?
different question over.
Objection. Speculative.
No. You can approach.
I have no snark left in me. This lady is obnoxious, malicious.
So if the injunction were granted on that day, what was your plan about moving to Maryland with Doug?
I don't know that I really had a plan. I wasn't even sure whether or not I was going to go through the injunction at that point.
There's something funny.
Take care.
Okay, so I want to get to the night that all this happened. So you knew Doug was coming over.
Yes.
You invited him over
Yes.
to help you move stuff in the house,
Well, specifically stuff in the garage, but yes.
stuff in the garage to the truck.
Mm-hmm.
Right. And he came to your house a couple of times. He came and then left and then came back again.
Yeah, I believe he came twice that day.
And there is a gate to your community.
Mm-hmm.
And when he's at the gate, you had to let him in.
Sometimes, because he was frequent in and out, sometimes the gate remembers license plates, and sometimes it opens and sometimes it doesn't. Sometimes he would just follow people in. The gate kind of stays open for a while. Yeah, sorry.
But on this day, you weren't concerned about him coming over.
No, I knew he was coming.
Okay. And when he came over, your mother and Emerson went to the park.
I believe they were headed there. I'm not sure. I think they were down the driveway or on the sidewalk, something like that. They were on their way there.
You weren't so afraid that you wanted your mother to stay there and watch.
No, we were just packing to move.
Okay, so you weren't afraid.
I definitely didn't expect this to happen.
So it was okay with you that your mother left?
Yeah, at that time.
Okay. So if I heard you right during your direct, you said he bumped your shoulder twice. Body check, I don't know if that's what you called it. He walked into you with a box, right?
Yes.
And then at the end, you say he slapped you?
He hit me. I wouldn't know how to classify it. He struck me, he hit me.
Was his hand open or closed?
I don't remember.
Okay. And because of those things, you claim that you thought he was going to kill you.
He had never hit me before.
Okay. And you thought he was going to kill you.
He wouldn't let me leave. I tried to leave, he stopped me.
The question is, you thought he was going to kill you.
Yeah.
Okay. Now, when you were in the bedroom, you decided to get your firearm. And it was where?
It was in a storage bin on top of the laundry basket.
Okay. So I'm going to show you State's Exhibit 52. If you could turn around and look at that. Where was your firearm?
It was in the bin on top of the basket.
Here?
That's the basket. The laundry
Where was the
basket.
bin?
It's that right on top.
Okay. So it was in here.
Yes, ma'am.
Why would you have a firearm in there?
I had just emptied all the furniture and everything out of my room, and it was kind of like what was left from my drawers, and so it got put into a bin.
Okay. And that was not your only firearm in that room, correct?
Correct.
You had a firearm in the closet.
My carry gun was in my backpack, which is my purse at the time.
So in this room, with a mattress and a broom and a hamper, you had 2 firearms.
Yes.
So you go into the room and you grab your firearm. Is it in a holster?
I don't remember.
Okay. And you claim that Doug does what?
He came and slammed the door open. He was standing in the doorway. He said, "You're fucking done."
He said, "You're fucking done." And that made you fear for your life.
Yeah.
Can we turn the lights up, please? Thank you. So he says you're fucking done, and you point the gun and you shoot.
I held it out in front of me first so he could see it. And I said, "Stop."
Judge, if I could have her step down so she can demonstrate.
You may.
I would object to that.
So Doug opens the door and does what?
Standing in the doorway. Here. Like this. He said, "You're fucking done." And I held the gun out in front of me. I said, "Stop." He got into this like fighting mode, literally like turned sideways. And he was like moving around with his like arms in his hands. And he started like inching forward towards me.
So he why do you call it a fighting stance?
He looked like a fighter. I don't know, like a ninja or something, I don't know.
Okay, so he's standing there, he turns to like this and starts moving his arms around.
Oh my God.
Well, show me, what was he doing?
You know, like I really got like this, and he was like making like fighting motions. I don't know, I'm not a fighter, I don't know.
Okay.
It was scary.
Did he have his hands in fists?
Not at that point, they were like, I don't know.
Was he coming at you like this?
And he lunged at me, he came really quickly.
Okay, so he lunged. Was his fist up when he
I
lunged?
don't remember.
Okay. So you start shooting, and he does what?
He kept coming at me.
Okay, so then you keep shooting again. And he falls down on his back.
His legs went up in the air.
Okay, where do his legs go?
In the air.
How high in the air?
I don't know.
Do they go over his head?
I don't know. It's like his feet slipped out.
Okay.
And his feet and his legs went up in the air.
And were you still shooting at the time?
I don't remember.
You can have a seat. So after this incident, you claim that you had swelling to your face, right?
It's going to take a minute. All right, there's the jury. Can you please close up your notes, put them on your chairs. I'm going to ask you to step out for a minute. You can use the facilities. It's not quite our mid-afternoon break, but we'll treat it as such. Please don't discuss the case amongst yourselves. Don't discuss it with anybody outside the jury. Don't do any research like we've talked about. All right, the jury's out. You can have a seat.
Sorry.
All right, we'll take 5 minutes. Yes.
And you know the prosecutor did that on purpose. Which makes me mad. I've had about enough with the prosecutor. I don't know about anybody else.
Deliberations, you're free to use your phones, but don't communicate about the case with anybody else. So I'm going to let you.
What's going on?
I'm sorry. So I'm going to let you step in the back so we can have our legal conversations. I'll get you back out as soon as I can. Don't begin your deliberations. You're free to use your phones, but don't communicate about the case with anybody outside the jury. Don't do any research on those things.
Before you start on that, The clerk just confirmed she got all those exhibits back. I just,
Well, you can all have a seat.
okay,
She
thank
count-
you.
She counts them on a regular basis.
Thank you. I just didn't want to have any over here.
Yeah.
There's still 3 hours of this. It's gonna be a long afternoon. Long afternoon.
Okay, so we got a proponent, we've got an objection. Is the witness in here?
She's right on time.
Okay, good. I want to make sure she stepped out. Okay, so the defense has called a Miss Sweet, who apparently is a former prosecutor in the 12th Circuit.
Yes.
And she, if I understand correctly, she was assigned in the misdemeanor division, the domestic violence division, and the case, the alleged violation of domestic injunction regarding the T-set was assigned to her.
Correct.
And you expect her testimony to be that she intended to file the charge, she was waiting on some receipt,
Receipt of the package.
like a mailing receipt,
Yes.
that would have shown what, the return?
That Stephanie Murphy gave to Detective Gillen.
And then you believe her testimony would be that she intended to file the charge, but then she was transferred out of that division.
She left the office.
They left the office, okay. Because that's one of the temporary assignments that they give to misdemeanor folks. So she left the office, and that's it?
Well, and her training based on domestic violence training, she believed Ashley to be a victim of domestic abuse, and that Ashley exhibited all the symptoms of domestic abuse. In particular, remaining quiet as a result of intimidation and going, for example, the state's case is predicated on Miss Benefield going along with Douglas Benefield. For example, on the first parent sharing exchange and the week leading up to the shooting, they put in those 263 text messages and the video at the restaurant, all showing Miss Benefield and Mr. Benefield's company as apparently happy and not afraid. And abused, those are the classic symptoms exhibited by abused women. They are afraid to reject the abuser for fear of reprisal. And what happens is after a while, they reach a state of compliance where physical threats are no longer necessary because they know what potential is. So they become compliant. That's also what Bruce Ferris is going to enlighten the jury on. And I remind the court that this is the state's theory. They have put into play, they injected it, they raised it, initiated it, that because Miss Benefield didn't look scared in the company of Douglas Benefield, and that she was exchanging these text messages with him for the week leading up to the shooting with smiling faces and basically compliant behavior, that shows that her claim to fear of Douglas Benefield on the 27th is a fraud. And we now need to explain to the jurors why an abused woman would act like that and would, for example, not agree to be present at the first parent sharing exchange. When a child is involved, it magnifies the situation so that the mom, if she's afraid of, in this case, Mr. Benefield, because of prior acts of domestic violence, she's even more afraid for her child. So the mother's going to make it a point to accompany the abuser in an effort to protect her child. That's what we are now obligated to show to properly defend this case. And we can do that through the training and expertise of Samara Sweet, as well as Bruce Ferris.
Judge, first of all, this witness was not listed as an expert, because if she had been listed as an expert, I would challenge the qualifications to be an expert. Just for your honor's knowledge, we did not have a domestic violence unit at the time. I know our office has in the past. We did not have a domestic violence unit, so she was not in any domestic violence unit. Even if she were an expert, there is absolutely no way that she could testify that she felt that Ms. Benefield was exhibiting behaviors of an abused person. I think it's completely improper. And the issue of the decline of the injunction, or the fact that Ms. Sweet intended to file, is irrelevant. I can tell your honor, and for the court's knowledge, it's because when we got the receipt, when that package was sent, that receipt showed a date that was a problem for us. And that is why that case was declined. So the decision was made after Ms. Sweet left the office and we received the receipt. So the fact that she would be testifying, I believed her and I wanted to file it, is completely and totally irrelevant.
Yes, sir. Rebuttal?
Yeah, so the court may recall that Deputy Weber had issued a capias for the arrest of Douglas Benefield for the delivery of this package. Detective Gilliam came into court and told us that he suspended Deputy Weber's request for a capias, and we have a communication from Deputy Gilliam that we got by way of a public records request, where he acknowledges plain as day that it was a violation, that it was during the time that the South Carolina injunction was in effect. But he nonetheless refers it to the state attorney's office. This is the assistant state attorney that was working that case. She would testify, we'd like to put her up for a proffer, that she fully intended to file. She believed it was clearly a violation based on the fact that the court.
Well, I'm just saying, if you want to proffer, let's get her in and proffer, because then all these arguments would happen after the proffer.
Okay.
I mean, but I haven't made a ruling, so you can make your argument, I can make a preliminary ruling, and then you can proffer?
Yeah.
Okay. Mr. Taylor, you didn't go outside. So, listen, how about I do this? The jury's out. It's about 3 o'clock. I'm thinking maybe give them a 20-minute, a longer afternoon break. When I do that in the afternoons, I will typically have a deputy escort them down to the jury assembly room where they can kind of spread out. The machines are there, the restrooms, but deputies are with them. Okay? All right, deputy, can you excuse them until about 3:20? We'll get them back up as soon as we can. Thank you. Yeah, it's a profit. This basic purpose, right hand is one.
You solemnly swear affirm the testimony about to give the truth, the whole truth, and nothing but the truth.
I do.
Cool, man. My name is Judge White, I'm presiding over this case. As the deputy said, just make yourself, go ahead and sit down, make yourself comfortable in this seat. Pull yourself up so you're about 12 to 15 inches from that microphone. There you go, to adjust up, down, left, right, however you need it. Speak in a loud, clear voice, you'll hear everything. As you can see, I'll tell you, you're a former prosecutor and attorney. Jury's not here. At this point, the defense is going to proffer your testimony.
Okay.
Afternoon, Ms. Sweet. Will you tell us your full name and spell your last name?
Yes, Samara Sweet, Sweet.
Are you currently employed?
I am.
What's your title and where are you employed?
I am the trial lead of counsel at Lydecker, which is a civil litigation firm.
All right, and you're a Florida bar licensed attorney.
Yes, sir.
At one point, were you a staff attorney for the Manatee County State Attorney's Office?
Yes, I was.
How long did you serve in that capacity?
So there from 2018 to 2022. It's about 4.5 years, I believe.
All right, and during that 4.5 year stint, was there any special assignment that you held?
I began with the misdemeanor division here in Manatee County. After 6 months, I moved to Arcadia. So I was in DeSoto County, where I started in misdemeanors and moved up into felonies, where I would have dealt with anything from possessions of controlled substances all the way up to child sex crimes and murders.
Specifically, did you have any training in domestic violence?
We did. Every attorney at the state attorney's office does go through CLE's trainings on how to deal with domestic violence victims, because especially when you're working in the misdemeanor portion, a lot of your crimes are batteries and a lot of them are domestic violence victims.
Can you give us an idea of how many cases you handled involving domestic violence?
Oh, I think at one point my caseload was 700 when I was in Arcadia, and at least a third of those were probably something domestic violence related.
Did you deal with not only abusers, but the abused?
Yes, most of the cases I had as a prosecutor, my victims were abused individuals.
Were the majority of your victims in domestic violence cases females?
I would say a large amount were females, yes.
Were you assigned, while in your capacity as an assistant state attorney for the 12th Judicial Circuit, were you assigned to a matter involving Ashley Benefield?
I was, yes.
How did that come to pass?
So when I was in Manatee, I had the caseloads with all defendants that had the last names with B, D, or I. So Ashley Benefield's case came to me, and she was the victim in the case that had been assigned to me for a violation of an injunction.
Do you recall specifically the nature of the violation?
It was a package that had been delivered to her allegedly from her ex-husband.
All right, and the domestic violence injunction that was violated, do you recall from where it had been issued?
It was from out of state. I believe it was South Carolina.
And did you meet with Miss Benefield?
I did.
Do you remember on how many occasions?
I believe it was twice, because when the case first came, there's elements to a violation of injunction that have to be met. We had not yet had all the information, so I did meet with Miss Benefield, got some more information, and then had to follow up on the investigation. I had to meet with her again after that.
Did there come a point in time when you made a filing decision?
I did not. I have left the office before a filing decision was made. I had been moved to Arcadia at that point.
I should have articulated that question better. Had you, as part of your investigation, individually reached a conclusion as to whether or not you felt it justified going forward and charging?
I did. I think I was still waiting on some information to prove if the package had actually been sent by Mr. Benefield. And that was the last information that I had left to my predecessor before I left. But I did think that if that information was given, there was enough to file.
And would it help refresh your recollection if I suggested that you were waiting on a copy of the receipt for the package?
Yes, I was waiting on to see who had sent that. And I know I had been in contact with the officers involved.
Do you recall whether or not you were dealing with Detective Gillum?
That I'm very bad with names, so I do not want to say yes or no, sir, if it was Detective Gillum or not. That does sound familiar, but I might have worked with him on other cases as well.
All right. How was Ashley Benefield when you first met her? Can you describe her demeanor?
Yes, she was very upset. She seemed scared, worried. She had come to my office and she was crying when she was sitting in my office with me. I did think that she was worried about the package that had been received.
Now, was it your practice generally to always meet with the victims in the cases that you were prosecuting?
Yes, it's office policy.
Had you formed an opinion about the genuineness of the fear that Ms. Benefield expressed?
I did believe that she was in fear and worried about that.
And from the investigation that you conducted, did it vindicate, other than the actual label for the package, the factual representations that Ms. Benefield had made to you? Want me to restate that?
Yes, please.
Yeah, that didn't come out too good. Did your investigation corroborate the facts that Ms. Benefield related to you?
It did, yes. There had been a package received. The package, I know she believed had some weird smell coming from it. And my recollection was that had been investigated, but the package had been delivered to her. I think she said it was close to her birthday around that date. I can't remember exactly, but it did. The facts that I had investigated did lead up. South Carolina, when I reached out to them, had said they had given an injunction for her.
All right. And do you recall contacting the toxicologist with respect to the contents of that package?
I did. She had brought me a toxicology report on that meeting, and I did call the doctor. Now, in all candor, I can't confirm if that's exactly the doctor, but I did speak to someone on the phone who said that Ashley did have weird things in her blood system at the time that did not correlate to someone's normal toxicology. But she couldn't say from where that had come from, but that there were abnormalities in that report.
And
No.
you say you have considerable experience with women who have been victims of domestic violence?
Yes.
Is there a certain pattern in your training and experience that you see in these women?
Yes. So a lot of times we'll have a lot of these meetings involve an abuser. We have the abuser who has abused someone. By the time they're coming to us, a lot of time has passed. So we always want to explain to them that normally we see a cycle. You have an abuser, he does something wrong. Then it's, I'm sorry, I'm very, very nice. They come back, and then we end up again in this situation with more abuse.
Kind of like a hamster wheel.
Yes.
Did you form an opinion as to whether or not in your discussions with Ms. Benefield that she fit the profile of an abused woman?
I did. When we discussed, she did seem that she had been isolated at that time. She was very scared. The way she had spoken to me did give rise. She had mentioned some minor physical issues that had been occurring, but abuse doesn't always have to be physical. Sometimes it's psychological, mental, emotional. And she was in my office when she was sitting. She did seem to be presenting like that.
Is it a pattern and practice of abusers to employ psychological intimidation?
I mean, normally a lot of the times in the reports I would have, we would have something of threats or some sort of information leading up, text messages, Facebook messages, things of that sort.
And let me ask you this. Are these abused women, despite their fear, often in the company of the abuser?
A lot of times I've seen them return back to their abusers, yes.
And have you experienced abused women when in the company of the abuser acting as if everything is fine?
I wouldn't be able to say I've seen them with their abusers, but a lot of times if we were in court trying to present, I would see them come in to defend the defendant that we had or to withdraw claims and that kind of thing.
I guess the point of my questioning is merely because the woman appears content, is that an indication that she's happy in the company of the abuser?
No.
Why is that?
I have more facts by the time I've seen the investigations, I've seen interviews, things of that sort in our caseload. They might be presenting, telling the judge something, but clearly we've seen, photos of abuse. They've sat and given us recollections of abuse, that kind of thing.
You left the office before you were able to actually conclude and file a charging document.
That's correct.
And as you sit here today, do you know what the disposition was?
I believe it was decided to not move forward, so it was dismissed.
That's all, Your Honor.
Close.
When you were in the misdemeanor division in Manatee, I think you said 6 months.
Yes.
So what was the time frame then?
I know I had started, I want to say April of 2018. So it would have been 6 months from there because I think I got out to Arcadia around October, November-ish.
Okay. And was the misdemeanor job in Manatee your first job out of law school?
No.
No. Okay. Did you work, where did you work before that?
Before I worked with Eric Reisinger, I actually did criminal defense.
Okay. All right. So when you talked about the domestic violence training, were you referring to the domestic violence training at the state attorney's office?
Yes.
Okay. And was that the normal domestic violence that everyone is sent to, the class?
Yes.
And how long is that class?
I think it's 4 days.
Okay. And is there any other domestic training?
I know the office does some pretty good domestic training. They'll do PowerPoints, luncheons, things of that sort. I think there's some, I don't know if they still do it because now I'm aging myself, some field trips to like the TILA and some of those organizations that work with abused women.
Okay. Thank you. I don't have any other questions.
Thank you.
No, I think that's got it.
All right, man, could you step back out to the hallway, please?
Yes, sir.
All right. She's out. Proponent, you can start with your, there you go. She's waiting in the ante room. Now we got her in the hallway. Proponent of the evidence, argument.
Yes. So, Your Honor may remember that Detective Gillum made the allegations 2.5 years later, despite the fact that there was no earlier report documenting what he alleged 2.5 years later in any of his 2 or 3 prior supplements, that Miss Benefield acted completely inappropriately, that he did not believe that the South Carolina domestic violence injunction was in effect because even though the hearing was on November 3rd, the judge hadn't signed the order till the end of the month. And therefore, he countermanded Deputy Weber's request for a capias. This witness impeaches the statement by Detective Gillum because she was the assistant assigned to the case at the time, and she had made a decision that in fact she was going to file, but for the fact that she left the office beforehand. She had conducted the investigation, completed it. All she was waiting on was the label of the package, which, interestingly enough, the court may recall, Detective Gillum recovered from Stephanie Murphy. But it apparently didn't make its way to Samara Sweet until after she left the office.
All right. And the objecting party?
Judge, I would object. I don't think she can testify as to anything. She just testified to. I think most of it is opinion, and she is not an expert. And even if she was an expert, she wasn't listed as an expert. So she cannot give opinions. And any opinion about whether someone, as a prosecutor, whether someone violated the law or not is inappropriate testimony for court. A lot goes into filing decisions. The prosecutor has discretion the same way police officers have discretion. To add any significance to that, I think would be completely improper. And so I would object to anything to do with her decision-making with the state attorney's office. And also, as I said, I think there was some information.
So she was unqualified to work at the state attorney's office because she has no qualifications to render opinions and do any functions in the state attorney the office of the state attorney. That's what she's saying.
It was gained after she left that played into that decision. But additionally, I think she would not qualify as an expert of domestic violence, and I think even if she could, a lot of those things would be inadmissible anyway, but she would say.
All right. Mr. Taylor, do you have any final thoughts you wanted to put on the record? Any final thoughts? Rebuttal?
That's good.
All right, thank you. So one of the very interesting things about this case as we have gone along is there's been some very interesting, and I think I said the other day, unique legal arguments that have been made. Certainly, I would like to think it's in honor of the Olympics starting tonight that you guys have put me through my mental gymnastics for the last couple of months. You know, another judge that's here in Manatee County, I hear him say this a lot, and I think it rings true. There are some very difficult decisions that we make as judges, emotionally difficult, legally difficult, factually difficult. This is not one of them. This is a very, very clear and easy decision. I'm going to put the part about Ms. Sweet offering any sorts of opinion as an expert kind of to the side because I resolved this matter well before I consider that she wasn't listed as an expert and the Richardson aspects of that. And what I want to focus on is the purpose of allowing these other incidents of violence or threats is, as we all know, it's one of the carve-outs of obviously case law provides an exception in stand your ground in self-defense cases for battered spouse syndrome. Normally, any peculiarities for a particular defendant, PTSD, low IQ, mental health are the ones that come to mind quickly, are not relevant and not admissible in a self-defense case because it's a reasonable person standard. So battered spouse syndrome is the carve-out, and the idea by once the defendant has laid the predicate of the overt act, allowing either reputation, and if it's reputation in a relevant community, we've all agreed, well, should agree, the case law says that the defendant doesn't have to know about that. It's just reputation evidence. On the flip side, whenever you want to get into specific acts of violence, threats, intimidation, and I know our net that we've casted here is beyond just prior acts of violence. There's also been issues of threats and intimidation. It's come in, it's in. The case law talks specifically about why that evidence is allowed and why all of that is not hearsay, because it's not offered for the truth. It's offered to show the jury, what did the defendant know at the time that the self-defense was used? And unlike the mental ailments I mentioned earlier or other peculiarities of the particular defendant, this is just to show why the defendant would have stayed, and even if there wasn't an imminent violence at the moment, why that person would feel terrified, and all the other bad spells. I won't go into the whole thing. So the issue is not, did this assistant state attorney believe the defendant? Did this police officer take a report and submit a capias, or not issue a capias and send it to the state as a non-arrest? Did this ASA file it or not file it? Did this ASA believe that the defendant was the victim of domestic violence or not? All of those things are completely irrelevant, not to mention prohibited from the witness commenting on ultimate facts or invading the province of the jury. The issue is not the truth or falsity of the violation of injunction or the shooting into the ceiling or any of those issues. That's not the issue. The issue is, was the defendant aware of these prior acts? Example being that the evidence came in regarding domestic violence by Mr. Benefield against his first wife. The way the defendant learned about that was some sort of text message by or between Mr. Benefield and the former Mrs. Benefield. Clearly hearsay. But why does it come in? Because she was aware of it, and it shows some violent tendencies, so she can testify about it, she can talk about it, the jury hears about it to help understand what she knew, and this is in the jury instructions as the attorneys know, what she knew at the moment that this incident was happening. So Ms. Sweet's testimony about whether she believed the defendant or not, whether she was going to file or not, the conversation, that whether she thought that the defendant was genuine and legitimately a victim, the testimony that she had some report and she called someone and there were some sort of abnormalities, unspecified abnormalities in some lab test, that she, characteristics of domestic violence victims and so forth, is just of no moment. So it's irrelevant. It's commenting on the testimony of and the credibility and veracity of other witnesses. It's commenting on ultimate facts. If you want to talk about the expert portion of it, as the defense said, this is all the same things that Ferris is going to testify to. So in essence, I haven't heard his testimony, but what I understood was everything, I believe it was something along the lines of what she's going to testify to is the same as what Mr. Ferris is, and I only say Mr. because I don't know his professional designation. So Mr. Ferris is going to testify to. Finally, on the issue of 403, Ms. Sweet's testimony, the probative value of that is substantially outweighed by the danger of confusion of the issues and misleading of the jury, because it does not matter whether that particular person believes it was a violation of injunction or not. The point is, the testimony is out. It's been demonstrated that the defendant knew about that. She's alleged it was a violation of injunction. There's a dispute. That'll be a factual issue for the jury to determine. But she's alleged it was a violation, which she took as intimidating. And the smell that caused her headache was some sort of physical ailment that would have been caused by the present that was provided. I understand that's her position. State might have a different argument on all that. But this is not even a difficult question. Miss Sweet is not admissible as a witness. I am glad you proffered though, because now it's all on there. But no, she's not going to be allowed to testify to what I heard today. Do you have another witness we can call?
Yes.
All
Bruce
right.
Ferris.
We have an objection to him as well, Judge. We filed.
Oh, now, Mr. Ferris is the expert,
Yes.
and the state wanted to have a,
Judge, I'm sorry. We do have a lay witness that we want to get on. Amy Carlton. She's going to be quick. We need to get her back to work.
oh, hold on, Amy Carlton. And then, I assume, I know that's bad, that Mr. Ferris, tell me, does he have a professional designation? Is he a doctor or?
He's a licensed mental health counselor.
So he's Mr. Ferris.
Former deputy sheriff. His practice and his law enforcement experience has been combined exclusively to domestic violence. He teaches batteries.
I just want to know if he was had he a professional designation that I should
Yeah.
use. All right, so Mr. Ferris, looking at the time, I would think that after we finish with Ms. Carlton, the Daubert hearing is very likely going to take us to the end of the day. So I expect that we would probably start with Mr. Ferris on Monday. Mr. Taylor?
Well, Your Honor, actually, we have some case law that I was hoping would obviate the necessity for a Daubert hearing.
All right, well, do you want to handle Ms. Carlton first?
Please.
All right.
Ms. O'Donnell just needed to go to the ladies' room, so.
Oh. All right.
I mean, if you want to bring them back in, that's fine. If you
Well,
want,
yeah, we can start working them back up.
yeah.
I think that'll be good. So let me give you guys 5 minutes. If you need to step out, Mr. Taylor, Ms. Benefield, if you need to step out and use the facilities, that'll be fine as well. We're going to start working on getting the jury up. It usually takes about 5-10 minutes.
Yeah. Okay. Thanks, Judge.
I don't remember the state letting her go. I guess it doesn't really matter, but I don't remember the state. That was one of her friends at the wedding reception. I remember her breaking down and crying. I don't know. I missed it somehow.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Hello, ma'am. My name is Judge White. I'm presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, or right if you need it. And just speak in a loud, clear voice and we'll hear everything. Can I just move you just a little bit forward?
Okay.
That's perfect. Thank you. Yes, sir, Mr. Taylor.
Good afternoon. Would you tell
Good
us your full
afternoon.
name and state your last name, please? Spell your last name.
Spell my last name? Carlton. Carlton.
And your first name?
Okay.
Tell
I'm
us.
sorry.
What is your first name?
Amy with a Y.
Okay, Amy, or Miss Carlton. Are you presently employed?
I'm presently employed, yes.
Yeah, where?
Where?
Where? For who?
I'm at one of the hotels in the area.
Okay, and what capacity do you serve in at the hotel?
I'm one of the managers.
How long you been doing that?
What was that?
How long you been doing that?
I've been with the ownership for 4 years now, going on 5.
Are you married?
Yes.
What's your husband's name?
Herbert.
Miss Carlton, were you and your husband Herbert living in Bradenton, Manatee County on September 30th, 2020?
Yes.
September 27th, 2020.
Yes, we were.
Do you recall that afternoon if you were outside with your husband?
Yes, we were.
Do you recall the address you lived at back then?
It was on Newport News Street or Drive. We've been renting, so to be honest with you, I don't recall the exact street, the number of the street, but it was Newport News.
Do you recall, Miss Carlton, whether or not, what was the reason why you and your husband were out that afternoon?
I have a mini golden doodle, and we were taking a walk.
Did anything unusual occur while you were out with your husband and the dog?
The reason I'm here, you know it. I mean,
Would you share it with us? What happened?
we were taking a walk, and Newport News is a couple streets over from the incident area. And it was probably 3 houses down where we were. And at the time, my dog was probably just over 1. So I don't know. I'm a big dog lover, and she's my life outside of work with my husband. He and I both heard what I don't know. I didn't know what it to be, and he kind of grabbed my arm, and I kind of got startled because it did sound like gunshots. I don't know, at the time we didn't know what it was, and but we heard one right after the other, and me, because of where I work, I'm trained like the attack or panic mode. I am thinking of myself. Sorry to be selfish, and my dog and my husband. And he's looking ahead too. And I just remember being a little bit terrified myself and thinking of myself, my family. And so I remember looking up and telling him, well, let's go, let's turn around, let's go back behind the house, because at the time we weren't sure what it was. And also being trained, you don't know what is to come next. First of all, you don't know what it is. So as I'm telling my husband, I told him, call 911. As I'm telling him that, I'm sorry, I'm backing back behind the house because you don't know what's coming next.
All right, let me ask you a couple of specific questions if I can.
Yes.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, after you heard the gunshots, did you observe anybody exit a house?
Quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I mean, I don't know exactly, like timing wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house, and
Describe.
I remember screaming, and that's just the vivid recollection and memory that I have, just the screaming. And came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes, yes.
I want you to tell us, Miss Carlton, after the gunshots, approximately how long it took for that woman to come running out of the house.
Oh. So I'm not sure I recall. It was within seconds, though. It was, I don't know. It just, I mean, I didn't even have time, like I said, to pursue any hiding places. It was so quickly.
Do you remember speaking to the police about the incident?
We had an interview, yeah. It was probably 30 seconds, a minute. I don't know, 30 seconds.
Okay. So you hear the shots, and within 30 seconds, a screaming, hysterical woman comes running out of the house and goes to the neighbor's house.
Yes.
Did you hear banging on the door at the neighbor's house?
I don't recall if I remember stating that or not, but I remember the hysteria of the screaming.
Okay. That's all I have, Your Honor.
Can the witness be released?
Yes.
Yes.
Thank you, Ms. Carlton.
Thank you.
Ma'am, you've been released from your subpoena, so you're free to go. Thank you.
Did he need that for foundation? Is that why he called her?
All right, go ahead and approach.
He must have needed that for foundation. My doggy is asking. So I'm going to take a quick break here because she's asked a couple times now. So we'll be right back. Okay, we're back. Doggy went outside for a while, thoroughly enjoyed it. I pulled a couple weeds, 12:30 in the morning. And let's go ahead and go back to the courtroom. I still don't. How did I miss state saying no more questions? All right. It looks like the expert will be coming on next. I don't know why they had the one witness on there. Within seconds, within 30 seconds, after hearing gunshots, she saw Ashley leave the house and bang on the neighbor's door, screaming hysterically.
There's the jury. So the attorneys and I need to talk about what's going to happen next week. We got to do some legal matters that are outside the province of the jury. So at this point, I'm going to let you go for the weekend. It's about 10 till 4, so you're free to go at this point. Remember the rules for the weekend. Please do not discuss the case amongst yourselves. Don't talk about it with anybody else outside of the jury, and certainly don't do any research on the people, places, things, or legal topics you've heard anything about, and that includes being very mindful of watching out for any media that may be on anywhere you go and wherever you might be to avoid all of that. Okay? Listen, do you still have your parking passes?
Yes.
Everybody's got that. If you've lost your sticker, is there somebody downstairs in the jury room? Okay. Oh, you've got a bunch of them?
Yes. He got us a bunch.
It's like pads and everything. We got them everywhere. Okay, great. So make sure you keep that parking pass. If something happens and you lose it, you're gonna have to come in Monday, see the jury coordinator to get another one, and then go park, because they will give you a ticket or tow you, one or the other. All right. So thank you very much. It's been a great week. Yes, ma'am.
What time do you want us here Monday?
I always forget that part. We're gonna start at 9 o'clock on Monday. So if you can be downstairs, 8:30, 8:45 is just fine. Listen, I will say this though. Remember on this past Monday, how there was a whole bunch of people? That's how it's gonna be this coming Monday, because we're gonna be picking another round. Other judges are gonna be picking other rounds of juries. So you don't have to necessarily stick together, but you're probably gonna wanna be off a little bit. Unless you wanna tell the other folks there how great jury duty is. That way they won't try and get out of it. All right, great question. Sorry, I forgot about that. Thank you very much. You are free to go for the weekend.
Thank you, sir.
Thank you. All right, you all can have a seat. I will tell you, I don't think I need to hear a whole lot more about Mr. Ferris. I think we've talked about it quite a bit. I'm ready for the hearing. I will say this: it is a hearing, so if you want to make an opening, don't feel like you can't. You're absolutely free to make an opening if you want, Mr. Taylor. So please don't let me dissuade you. If you want to make an opening, make an opening.
Not necessarily.
State?
No, Judge.
Thank you.
I think we've talked about it.
Another box.
You saw this from testimony about to be the truth, the whole truth, and nothing but the truth.
I do.
Let's prove he's a expert witness. He has to prove it.
Hello, sir. My name is Judge White. I'm presiding over the case. We're going to have a Daubert hearing. I'm sure you're familiar with that.
Yes, sir.
So just put yourself about 12 to 15 inches from that microphone. Make yourself comfortable in that chair.
Okay.
And we'll get started with the hearing.
All right.
Prove here.
Good afternoon.
Good afternoon.
Tell us your full name, please, and spell your last name.
Bruce Eric Ferris. The last name's Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor. I do individual therapy, and also I do consulting on domestic violence and expert witness testimony.
Let's discuss your education. Would you inform us, please?
Sure. I have a Bachelor of Science degree in civil engineering. I also graduated at the local police academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
Do you have any specialized education or training in a specific field?
I do. If you look at my curriculum vitae, I think there's over 100 items listed where either classes or seminars or teachings and certificate training that I've attended.
And included in that, would domestic violence be a major part of it?
That was the definitely predominant theme of whether it be a specific class or a conference, et cetera, on domestic violence and intimate partner violence. And if you'd like, I can explain the difference.
Please.
Domestic violence has to do with what we might think of people have a child in common or family members. And that doesn't necessarily mean an intimate relationship. It could be two relatives living in the house together. Intimate partner means there's an intimate relationship, a spouse, a boyfriend, girlfriend. So there's a little difference there.
Try to make sure you
okay.
Voice in the microphone because it tails
sure.
off.
Thank you.
Mr. Ferris, have you taught any courses or presentations in a specialized field?
I have.
Please enlighten us.
If you look at my CV, I've given, I think, over 40 some presentations and teachings. For 8 years, I taught Batter's Intervention Program class to offenders, uniquely that. And for anyone that doesn't know, Batter's Intervention program is for offenders. It's usually court ordered, part of probation or part of a sentence or part of an injunction or a restraining order. It's a 6-month psychoeducational class. I've been training for that and teach that. I also I used to teach Gardner Lightham volunteers about domestic violence and effects on children. I taught the 8th Circuit staff at the state attorney's office about domestic violence and impact to women and children, and Batter's Intervention, how to interview people. From 2008 to 2020, I taught at the University of Florida Law Clinic on intimate partner violence to law students about the same type of subject, domestic violence and intimate partner violence and effects, and also enforcement of the law. I also trained police officers about domestic violence enforcement. Currently, since 2009, I've been teaching officers how to de-escalate confrontations as part of the crisis intervention training team. I teach the de-escalation part of that. There's a lot more I could talk about, but that's the nature, and you could see in my CV.
All right, let's talk about your work experience.
Okay, so I have an affiliation with Village Counseling Center, doing therapy, DCF cases, and domestic violence related cases. I used to also work with Creative Counseling in Gainesville, doing teaching Batter's Intervention Program classes and doing individual therapy. I also have my own practice now, and I do individual counseling. Recently, I just looked up, since 2014, I've treated almost 1,000 individual clients or patients as an individual therapist. Work experience we're still talking about.
Yes, sir.
Okay, of course, I mentioned the doing consulting for attorneys on domestic violence and being an expert witness. You're gonna want to know my current work or my past work?
Well, let's stay in the past. How about any experience with the Gainesville, Florida Police Department?
Yes. I went through the police academy in 1993. I was sworn in 1994. I retired from there in 2013. The last 10 years of my career there, I was the lead detective in the domestic violence unit, part of the Investigations Bureau, uniquely just looking at the domestic violence cases, enforcing the law, training officers, doing some public outreach, and being on various task forces.
Can you give us an idea over the course of that time, approximately how many cases you would have handled?
Yeah, I was a lead detective on close to at least 500 cases I looked up were resulting in arrest or charges being filed.
And what kind of professional credentials do you hold?
I'm a licensed mental health counselor in the state of Florida. I have certification to teach batterers intervention program classes through the state. I also received certificates to do threat assessments, domestic violence threat assessments through Jackie Campbell at Johns Hopkins University. Also trained in doing counseling and work with adoptions through Rutgers University.
Have you been the recipient of various awards and recognitions?
Yes, I have. I was chosen by the Alachua Board of Commissioners to be recommended to Governor DeSantis to be on the Alachua County Child Fund, tax fund, I guess they call it, trust fund, excuse me. I've also received various awards as the for my domestic violence work through the local shelter. I received a statewide award from Attorney General Pam Bondi and Governor Scott at the time for my work. In 2010, I was awarded and recognized for my work with victims of crimes in the state. There's several other ones. Without looking at my CV, I don't recall them all.
Sure.
I received some recognition of the contributions for the work I did with that CIT team. The University of Florida also gave me recognition for training that I'd done with their officers. I was Big Brother of the Year, and for my work with my little brother for about 10 years, I worked with a little kid as my friend. And I was also the Law Enforcement Officer of the Year, as granted by the Domestic Violence Abuse Network in Gainesville.
Are you a member, Mr. Ferris, of any specialty boards, committees, or professional organizations?
Sure. Again, relying a little bit on my CV because of the nature of the question.
That's fine.
So in 2022 to 2024, I was a member of the Rape Crisis Center Advisory Council. I was a member of the American Mental Health Counselors Association, a retired member of the Fraternal Order of Police. I was a member of the 8th Judicial Circuit, Florida Family Law Advisory Group, member of the Gainesville Domestic Violence Task Force. I was a member of the 8th Judicial Circuit of Florida Domestic Violence Fatality Review Team. I was a board member of the Gainesville Commission on the Status of Women, member of the Alachua County High Risk Domestic Violence Team. I got some recognition for my work as a volunteer at University of Florida College of Medicine. I was doing mobile outreach part-time as a volunteer. I was a member of the University of Florida Male Leadership Committee, again, dealing with domestic violence. I was also on the planning committee for the sexual battery conference in Gainesville for many years. I was a member of the Gainesville Mental Health Consortium, the United Way Community-Wide Strategic Planning Safety Committee. I was part of the working group for leader for domestic violence coordinated community response for local law enforcement and best practices procedure. And I was a member of the statewide domestic violence needs assessment group organized by the Office of State Courts Administrator, Office of Court Improvements.
Have you been recognized as an expert by courts in the state of Florida? An expert in domestic violence?
Yes. Just as a footnote, I've been recognized as an expert in domestic violence in batterers intervention program class, effects of domestic violence on children, and generalized mental health work. I've been involved with about 60 cases, consulting or testifying. Not all of those did I testify. I did testify in over 50 of those cases.
Both civil and criminal?
Yes, both civil and criminal. Majority were in civil. The types of working both for the defense and the prosecutor of the state attorney's office, but the majority were civil.
All right. Would you be kind enough to educate us a little bit? What is domestic violence?
Okay. Domestic violence, excuse me? Oh, Domestic violence, according to Florida state criminal law, is acts of like battery and assault, ag battery, ag assault, false imprisonment, sexual battery, all these different person crimes from one family or household member to another family or household member. So that now the definition is what's a family or household member, and that's people that are married, living together, maybe had a child together, but have never lived together. People living together as a family in a house. It doesn't include, let's say, cousins that never lived together. So it's unique in that way.
And is there another definition of domestic violence?
Yes, and in my practice and in my training, this is a pretty accepted concept that domestic violence is actually a pattern of power and control. And the key word here is pattern. That's repetitive. And the criminal definitions, the physical things, those are used by perpetrators or abusers to control their victims. But along with that also is used control tactics. We often think about emotional abuse or those sorts of things, and they're defined in the Duluth Power and Control Wheel.
Would you explain to us what the Duluth Power and Control Wheel is?
Okay. So the Duluth Power and Control Wheel was developed up in Duluth, Minnesota by a group of researchers who deal with domestic violence. And what they did is they looked specifically at domestic violence cases that have been criminal cases, that victims who came through shelters, DV shelters, and they were looking for what were the tendencies or the tactics used by abusers against their victims. And they developed this power and control wheel. It's used around the country. It's the Duluth Power and Control Wheel is the basis for the Batterers Intervention Program class I mentioned. DCF, Department of Children and Families, has accepted that as a reality, a fact, and they that was the criteria or the curriculum for the BIP class used statewide and actually used around the country and internationally. So there's these 8 inner items, and on the outside of the depiction, I don't know if...
All right, yeah, let's see if, Judge, with the court's permission, we put the screen down.
Yeah, probably a little bit. So you can see. That's perfect. Yeah, thank you.
Judge, may I ask you a question? Could I stand over here?
Sure.
Rather than try to do it for easy.
Reposition as you need. It's just us.
Okay, thank you. Just a little easier to see this way for me.
Absolutely.
Thank you, Judge.
Oh, you know what though? The only thing is you can't be so far that the court reporter can't hear you, and she's listening to these microphones.
Okay.
So why don't you turn that?
Okay.
And then if you just position so you're facing there.
Okay. Can you hear me okay?
Okay, there
Can
we
you
go.
hear me now?
Yes.
So change that. So okay, so you can see that.
Yeah, I was gonna say, let
Yeah.
get
Sure.
your close.
Thank you, Judge. Thanks for reminding me. So this is the Duluth, as I said, if you look here, Domestic Abuse Intervention Project. And this was established some, I don't know, maybe 30 some years ago, 30, 40 years ago. And this is the standard used around the country and used for the Batter's Intervention Program class and a lot of counseling I do. This is part of the counseling along with cognitive behavioral therapy is one of the therapies I've been trained in graduate school and my work. So on the outside here of domestic violence is physical violence and sexual violence. And that's covered in the state statutes, the criminal law statutes. Then there's these 8 items that are part of the power and control. And remember, I said it's a pattern of power and control. So that means it's repetitive, a way to get your, it's a way for the abuser to get their victim to comply, to get into a compliance mode. I'll talk about that in a moment. So the first item is using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons. Those are I run into this all the time in terms of using intimidation. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy. It's very common. Playing mind games, humiliating her, making her feel guilty, using isolation, controlling what she does, where she goes, who she sees, oftentimes spying on their victims, checking their phones, tracking them, etc. Minimizing, denying, and blaming. I find this in almost all the cases I work. They make light of the abuse, say it didn't happen. They shift responsibility. It didn't happen, it wasn't that bad. It was your fault. So minimizing, denying, blaming. Using children, sometimes put their victim, the mom, in fear of what he'll do to the child or that he'll report her, etc., that she might lose the child. Male privilege, this has to do with the role that he makes the decisions in the family or in the relationship and gives her a specific role. Economic abuse, and this would maybe be preventing her from having a job or money, or she should have an allowance, etc. And then the last item is using coercion and threats, making, or I'm just having problems reading the fuzz here a little bit, making and carrying out threats against her, threatening her, using coercion and threats. So I'm going to sit here, that can stay up, and I'm going to make a few comments about it. So the main issue here that, as we understand the power and control wheel, is these are techniques that the abuser uses to control their victim. And like we say, it's a pattern. So that means it's repetitive. And so what's the purpose of that? It's to get them to comply. And so the victim ends up trying to avoid the perceived danger that they'll experience if the abuser perceives that they're opposing them. That's particularly true for mothers that are, not only are they trying to protect themselves, but they're protecting their children. And I found that there's victims of domestic violence tend to get into what I call equilibrium sort of stasis experience. In other words, they avoid the perceived threat. So they, the proverbial, the old phrase of walking on eggshells. So they end up being in this compliance, kind of like they don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perceived threat. So they, the proverbial, the old phrase of walking on eggshells. So they end up being in this compliance, kind of like they don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perpetrator and don't want to make him angry at them, because that's when the violence occurs, or the threats, or the emotional, the hardship. And that's exactly what the perpetrator, the abuser, wants to happen. He wants to keep her in line, so usually to manipulate, to get her to do what he wants to do, that they feel a sense of ownership, and they use these techniques to control. They also the victim wants to appear to be going along. They don't want to anger him. They'll actively hide that abuse from family and society, because if it gets out, he's going to be mad. I could speak certainly a lot more about that.
Are there, Mr. Ferris, common characteristics that abusers share?
Yes, they could be anyone from any socioeconomic group. I've been involved as a therapist and as a detective enforcing the law with all types of society and sexual orientation, from wealthy, well-known NASA scientists, doctors as a perpetrator, to the homeless person, and everyone in between. And in Gainesville, where I worked, we have a great population from all around the world there. And I didn't find a difference other than sometimes attitude, but every socioeconomic group, it's very, and also they tend to be males, but females also. Just yesterday, I took on a new client, spoke to him. His wife's in jail. He has 4 children with her, and he's a victim. So, he's a victim. So there's female abusers and male abusers. Males are predominant. I know when I was working, I ran some statistics on cases, and I found it was about over 2/3 of my cases were males, and less than 1/3 were females. And some of those, and that kind of reflected also when people would, kind of want to debate that issue about men or women. One thing that always struck me is when you look at fatalities, the statistics are about the same. There's usually the murderers are mostly men, by about 2/3 over the women. So the actual victimization cases and then the actual fatality cases, kind of the statistics I found ran together.
And what do they have in common?
Usually that they want to control their partners. There's kind of an ownership attitude. They use the power and control techniques I described to do that. I also find that they're in common. They're missing true empathy. I've kind of nicknamed it to myself as they're missing an empathy gene. And empathy has to do with the ability to feel someone else's feelings. And I find many of the perpetrators that I've counseled and also worked with in the BIP class, and certainly in my police career, they tend to be very selfish, a lot of narcissistic sort of ideas. I kind of image it as many of them, not 100%, but a majority. It's kind of like their point of view is I'm here and everyone and everything around me relates to me. I'm the center of the universe. As opposed to a healthy relationship, there's an equality. I'm being thoughtful and considerate of my wife as she is for me, and there's some balance. They don't necessarily adhere to that. They disguise how they treat their victims. Usually they don't want to let other people know about that, much like the isolation element. They want to keep it And there's reasons for that. And some of it has to do, they don't want to go to jail if it gets out. And then they don't want, I found this a lot, that perpetrators don't want their victims to get the idea that they're not a good deal, that there's something they're doing that's wrong, so they isolate them from society as such. And they'll put on a real front. I have numerous cases like this, how they disguise, how they treat their victims. There can be, the victims, the perpetrators, can oftentimes be very appealing, and they're very good at convincing people of things. I found a certain finesse amongst those thousands of BIP clients I had, that there were some very good talkers. I'll just leave it like that. But emotional and physical abuse is certainly what we think of. I've certainly worked a lot of cases where there was broken bones and bruises, etc., and emotional abuse and isolation and coercion threats, etc. But many of the cases I see, there isn't acute violence. It's emotional abuse. It's these techniques. The question is, can the abuser convince the victim that they're in, and put them in fear so they adhere to what they say? If they can create the fear, like this one lady told me, she was in fear of him so much, they would be in a public place and they're separated and they're across the room. And if he saw her talking to a male, he looked at her and she knew right away, end the conversation, move on. There was a fear, and there was no violence in that relationship, but she was scared of him. Also, as we know, as Judge knows, and Mr. Teller, the ASA knows, battery. In the state of Florida, there's assault and there's battery. Battery is the unwanted touching, that's the hitting, the punching, etc. But assault is also a crime. That's being in proximity to someone, showing a threat. I'm bowing up, have my fists up, and the victim has a perception that the violence is going to occur. That's a crime. Though there's no marks, there's no scar, there's no hitting, but there's fear. And so sometimes there's assaults that are taking place that aren't reported. And if on top of that, if they can create that fear to go along, that's a common technique that I see happening. It's all about keeping control, their victim. And one real common thing that I've seen is obsessive jealousy. And when I worked with batterers, I was surprised, and I came to learn very quickly that they oftentimes equate jealousy with love. And we all know jealousy can be very detrimental to the object of the jealousy, and also to the person having the jealousy, being obsessed and worried, etc. Love, we all know, is something else, completely different, very kind, considerate, and very empathetic, very different, but they didn't understand that dynamic.
Let me ask you, Mr. Ferris, do they exhibit, with respect to these characteristics in common, what is their behavior relative to animals, pets in particular? Domestic pets.
Yeah, I understand.
Cats. So
cats, dogs, etc. So there's above average abuse of pets by domestic violence abusers. So I have two explanations for that. One is what I talked about, their missing empathy, that they don't feel for a dog or a cat like I might feel. I'm very empathetic. I am in love with Rosie, my poodle. So is my wife, so that means a lot to me. But to an abuser who doesn't have empathy, it's not a big deal for them. They see it as an object. That's one thing. The more important item, especially in terms of power and control, has to do with that, to get back to the controlling of their victim. If that victim is attached to that pet and I abuse that pet, now I'm putting you in fear for what I'm doing because I'm hurting your animal. So I'll attack that pet as a way to control you. You better not, oppose me again, or you better not leave, or you better not go out with your girlfriends when I say you shouldn't, or I'm going to hurt your pet. I'm going to kill your pet even. So it becomes part of the continuum of power and control. And the sad part is I've also found that many perpetrators have that same mentality they use against their females, children, in the sense that the women are highly protective of the children. And so he's using the child as a way to gain control over the female.
And what about the abused, Mr. Ferris? Do they have common characteristics as well?
Yes, the majority are female, though, like I say, I treat male victims of domestic violence also. I'm still kind of surprised at times when I meet a new victim for the first time. And remember, for 13 years, I've been getting clients from our local DV shelter as a consultant and a therapist working. So I get kind of a constant feed of them. And then I also have my other sources and attorneys, and just my people know who I am. So they come to me if they're victims. But I'm always amazed at how many don't truly know what domestic violence is. And even I've had I've had clients who don't think they're a victim of domestic violence. They'll know there's a marriage problem, but they haven't been, I'm refraining from being too graphic because I've seen it all in terms of broken bones and types of violence in families. So they haven't been violently attacked and hit with the 2x4 or something. But I go over the power and control wheel, and they say, holy cow, this is my life. This is what's been going on with me. I remember one crime scene I was at, and the woman had been a victim of domestic violence, and she wouldn't talk to us. And I had a moment to speak to her, and I showed her the power control wheel and had a moment. There's a victim advocate there too. And we went over it, and all of a sudden it was like an aha moment. And she goes, darn. And I think it was a strangulation case. And she realized, and I've had some specialty training and some certification about being an expert in strangulation with the state, another subject. But she realized that she came within 4 minutes of dying for lack of oxygen to her brain. And once she realized the power and control wheel and how dangerous it was, she opened up and shared information, and that suspect who had left was eventually found. Also, statistics show that domestic violence victims will leave, on the average, about 8 times. They'll leave their perpetrator before they finally leave. It often happens. And there's also socioeconomic and ethnic groups that have unique attitudes to domestic violence. This idea of protecting a child for the mother as a characteristic is very, very significant. I guess I'll take a short moment. There was a particular case that comes to mind. This mother was very abused by her husband, and he made her stay.
I'm going to object. We've just gotten into a narrative. I think he's established this fact.
Sustained to the narrative.
Okay.
Okay, so you want me to skip the story? Sure.
All right. Describe what coercive control in a relationship means.
Coercive control are acts of assault, threats, humiliation, trying to create harm, punishment to frighten the victim, much in the manner that we're talking about a pattern of power and control. By creating fear, it's all working towards controlling the victim. Of course, like I say, the power and control wheel is the tactics. along with physical violence and sexual violence. And then we get into that appeasement or compliance that I've talked about. They want to avoid the pain of the conflict. And pain can be emotional pain. I've had women tell me, I rather get slapped upside the head, excuse me for the phrase, but then be told I'm ugly or fat, or my self-esteem totally crumbled. And so don't underestimate how important emotional control is in that sense.
Do these offenders always behave violently, or does abusive behavior happen in cycles?
No, as I've explained, it's not always violence. It's perceived violence in terms of the threats are enough to create fear in a victim that because of some assaults or, like in using intimidation, making her afraid by looks, actions, gestures, smashing things, destroying property, displaying weapons. These are all acts of intimidation that affects them and can create a great fear, and because of the narrative they project, the reality that they're living as the victim, and they get into this compliance mode, and it's can be very dangerous. There is, in terms of cycles in the industry, I'll call it, we recognize there can be kind of this rain, sunshine sort of model, that there's acute abuse, and that's kind of symbolic of it raining. And then the sun comes out and there's like a honeymoon phase with couples, and all the sun, everything's nice. There's no violence or no emotional abuse. And then all that rain with the hot sun, clouds form again. And then the clouds are too heavy to carry the rain, and then it rains again. So there's some relationships, not all, but there's this cycle of violence or emotional abuse, and then a honeymoon. There's also a cycle, a generational cycle that I'm aware of, that you grow up in a family where roles are very defined. The male is the head of the household. The wife doesn't, oppose him. So sometimes that cycle goes, I see it in my clients, from generation to generation until it can get someone breaks free from that. And maybe that male realizes that's not the best role to have. And a female realizes, I don't deserve this, and they move on. So that's another cycle.
Does the victim, Mr. Ferris, always appear to be afraid or act like they are afraid of the offender?
Definitely not. This gets back to what I've already been talking about. They're hiding that fear from friends, families, and for good reason, in the sense of the consequences of laying it out. And they may not understand all what's going on with domestic violence, but sometimes I've had victims say that they deserved it, that they caused the violence, that they didn't keep the house clean enough. They've got almost a brainwashing going on about what's expected of them as a woman, and they found this, I'll call it a dissociation from the facts. Mental health term, kind of an avoidance that allows them to comply because of their fear. And so it becomes, no, they don't always appear to be afraid.
So let me ask you this. How common is it for the victims to smile and act happy?
I'm an objector. I think we've gotten far afield from what needs to be established under daughter. As far as domestic violence, I'll stipulate he has this knowledge as to domestic violence at this point, but I think we've gotten far afield from what needs to be established.
Judge, I might recall for the court that they played the video of them all in the restaurant.
I'm not sustaining. This is your proffer, so
yeah.
You
Thank you.
You tell me what you want me to know about your expert, and I'll decide what he can say and not.
Thank you. Would you elaborate on how common it is for the victim to smile and act happy?
Very common. And it speaks to what I've already been discussing, that they try to hide the abuse from others for sometimes for personal reasons. They don't want him to get in trouble. I've had mothers that are financially dependent, and they don't want him to go to jail or prison, because how will they take care of their kids? So they sacrifice themselves. They are afraid of what society is going to say, or they're afraid of the abuser. So especially the afraid of the abuser is a really big part, and that they stay in line. And again, it speaks to this idea of compliance or equilibrium, as I call it, find the lowest resistance to survive. And so they get into survival mode, and that walking on eggshells. And as a therapist, when victims come to me, we've got to kind of untangle this stress and trauma and come to terms with that, because they've gotten kind of in this lifestyle of compliance and all the hurt that comes with that, and how their self-esteem's been damaged. I could go on and on with that subject.
All right, so tell us a bit, if you would, Mr. Ferris, the role that appeasement plays in domestic violence.
It plays a huge role. We could say appeasement. We could call it compliance. We could call it walking on eggshells. We could call it don't poke the bear.
Go along, get along.
Go along, get along. It's all about avoiding pain, and that's the very technique, the fear. I'll use fear as equivalent to pain. That is a way to control. Hence, why this is called the power and control wheel. These are techniques, along with physical violence, that are used to control their victim and get them. And there's an ownership. I've already mentioned a certain ownership, the jealousy, etc. And also, I found some of my abusers become obsessed with their partner, that ownership quality at all costs, and they're just highly obsessed, and it can get very dangerous, actually. I've worked cases where there's been suicide, homicide, that if I can't have you, nobody can have you. And if a victim realizes that their perpetrator's capable of hurting them, they're going to go along, or they're going to, get on a jet and fly somewhere real far away.
All right, tell us, if you would, what the impact of a child has on these dynamics.
So the impact to the child, or having a child in the scenario?
Having a child in the mix.
A huge impact. I found women who, certainly that want to protect themselves and do this compliance. But when there's a child involved, and if they have a strong maternal instinct, they're going to sacrifice themselves to stay in a relationship. I've worked many cases, to my surprise, where there was no reporting of the violence or domestic abuse occurring. And so the woman, the mother, wouldn't seek a divorce, because they knew, typically in our state, if there's no extreme reason, criminal history, drug history, violence, etc., it's going to be a 50-50 custody. So I have women who have stayed in the relationship, taking the abuse, because she's so concerned that she wouldn't want her child to be alone with that perpetrator. She sees him as a brute or a bad role model, etc.
And might that type of a scenario play out with the woman acting happy in an effort to go along and be in the company of the abuser to protect her child?
Without a doubt, that's the whole scenario. And and there are women that are better at it and more sophisticated at it than others. I'm just finished working a case where her family, as I interviewed, I won't make this long, but there was abuse. He's in prison. She was pregnant. She gave birth while he's in prison. She stayed with him. A couple of years later, she was she was running his business while he's in prison. She finds out he's getting out early in 3 months. She commits suicide. She hangs herself because she was so afraid of him coming back. The grandparents, the maternal grandparents, have the child. I'm working on that custody issue and the criminal cause. But the point I'm making is that when I interviewed the parents, the sister, the friends, all these people before the suicide occurred, they didn't know how bad the relationship was. She wouldn't show up to family gatherings, or she'd come and go, or they wouldn't see him. She was totally hiding all that extreme abuse that she was going through. The family didn't know about it till the end, before he was charged and went to jail. So she went to great lengths to hide because she was scared of him. And I believe her going along with him and running the business was all out of fear also. And then she couldn't face it and decided to leave us.
A few questions, if I can, as it relates to domestic violence abusers. What have you found in your experience and education as it relates to their ability to charm and deceive others?
Yes. I found this in a majority of the cases. They want to project an image, again, hide the abuse. Sometimes that's their strategy to deceive others because they don't want to be found out. Also, I might add that the recidivism rate, when I was running the BIP classes, I was always surprised. I'm getting the same guy back again, that there's a personality issue here that hasn't been solved per se with some men, and that there's a tendency to abuse over and over.
Is there a unique pattern of denying, rationalizing, minimizing, or blaming the victim that's typical?
It's not only typical, it's in a majority of the cases that I've ever worked. I see this almost in all the cases, I'll say. And if we look at the Duluth Power and Control wheel, there's actually at 5 o'clock, minimizing, denying, and blaming. It didn't happen. It wasn't that bad. It was her fault, which, as I've explained in the past. So that's very typical. It's also a form of gaslighting that's been in, I think, the news the last 10 years or something. So it's a form of control and gaslighting a victim.
Does it include suggesting that the problem stems from the victim's mental health problems?
Definitely. That's a very common theme. It's also gaslighting, and also it's in the power and control wheel, using emotional abuse. About the third line down, making her think she's crazy. So it's a destabilizing technique. If you've got so much influence over me that you convince me that I'm crazy, then maybe it didn't happen. Maybe I'm wrong. So it's a self-esteem killer.
Give us an idea, if you would, of the barriers that exist to these women leaving the abusers.
Fear of being harmed, certainly, if they report to victims. Barriers to leaving can be, as I mentioned, cultural upbringings or norms, roles. A lot of victims are financially dependent upon their perpetrators and don't know what else to do, and they don't necessarily have any other resources. Sometimes when I do trainings, I confront my audience, especially when I've got law enforcement or victim advocates, about their expectations of victims leaving that, perpetrator. You expect her to walk out on the street with 4 kids and she doesn't have a credit card and no family. And I kind of go into this a little deeper. I'll avoid doing that now. The fear of losing their children. So sometimes victims have experience with DCF. They understand what can be consequences if it's reported to DCF. So they don't want to report because, and I've been party to this in a lot of cases and termination of parental rights cases I've been involved with, that if she's staying with the abuser and a child, and I like I mentioned, I taught a class for DCF to men and fathers and mothers, and also trained on this a lot, that exposure to a child to trauma is trauma to that children. Separate from the traditional child abuse that we think of hitting the child or not changing the child's diaper, not having food, but actually subjecting the child to the yelling, the screaming, the abuse is trauma to that child. So if a female doesn't report and she's found out, then that can be considered a failure to protect. Now all of a sudden, and she's still a bona fide victim. So now she's being held accountable. Her children might be removed. She's got to go see people like Bruce Ferris for counseling. She's got to do all these classes. So there's and many know this, so they don't want that to be out and about. Also, sometimes I've had women, they still love him. They see the good in him. They feel he didn't have a good childhood, or it doesn't happen often, or maybe I created the problem.
So you mean these aren't split-second decisions?
What specifically?
Do they vacillate sometimes when children are involved?
No.
Should I leave? Should I stay?
I like to think of it as an evolution to leaving, but what's the motivation? If you're in that isolated situation of just he's the one, he's your world, where's the education? Where's the involvement? That's what the role of a lot of our domestic violence shelters are in outreach, and is to involve and educate. And yes, here's services you can have, here's someplace you can safely go. But that denial that violence will happen again is not uncommon. That feeling that it was her fault. Religious reasons. I'm always kind of surprised that, and I mean no ill towards any religious group. I don't mean to say that, but I found sometimes ministers or churches, very concerned about marriages and not getting divorced, and they actually recommend or counsel people to stay together that are hurting each other, and so that's an issue. This idea that he will hurt her if she leaves, in this quote, "I'd rather see you dead than with someone else," is not uncommon. And also the total power and control continuum and the use of that to control their partners.
Is there a particular time in these kinds of abusive relationships when violence is most likely?
Definitely. The most violent time is when she goes to leave and he knows about it, or he's there.
In other words, when he forms the perception that the realization sets in that this is the end.
When she eventually puts her foot down and makes that clear, and I know from my certifications doing fatality reviews with Johns Hopkins University, and then danger assessments, there's a high probability of fatalities or extreme body harm at that time. It's very dangerous. When we do many shelters and victim advocates that might be affiliated with the state attorney's office or wherever, they try to establish a safety plan with victims, and that plan will include, when you leave, it's when he's not home. Don't do it when he's home, and also have a safe, unknown location to go to. I have many stories I could tell of women being hunted down and actually killed because of he knew where they were. And that just the trauma of that, I don't, even though I work in this field and I've been doing it for 20 years, it's hard for me to conceive that cloud over me of being subjected to being violently hurt. And if I am, who's going to raise my child? And will he hurt my child also? It's overwhelming for those victims. And I certainly see that in my practice, my counseling practice.
So let me ask you this as we close. Given your education and experience as a law enforcement officer, tell me, is there a general bias against females by males?
I think there is. Some of it's different social, ethnic groups, different cultures. I think I mentioned earlier, ownership of women. I've had, without mentioning the countries, I've been in, like I say, Gainesville is a little stewing pot of people from all over the world. I've run into men who actually thought it was okay to abuse their wife because they thought she belonged to him. And I said, sir, this is America. That's not how it works. So this ownership can be cultural. It can be dictated by social norms, what their parents did. Certainly the media and entertainment plays a big part towards women and male roles in our society.
And where can this bias be found?
Everywhere.
Everywhere
in society.
Including our institutions?
Including institutions.
And would those institutions include law enforcement?
Law enforcement, and of course I worked in law enforcement, and I was always surprised at how I constantly had to, I actually became a little internal affairs detective for my officers who didn't understand domestic violence and had biases. And I was always surprised of the biases and found sometimes they were personal. An officer's going through a divorce. So all of a sudden he's at a crime scene and he treats the female badly because of his own world, not enforcing the law appropriately. But yes, it can be, not everyone reacts the same way as a victim to domestic violence, and especially with other people. Some people have developed a very fat affect. In other words, they don't show emotion, and that's their coping skill. They actually shut down. They do this dissociative sort of thing. Other people become hysterical and exaggerated in describing. So every person is different. Just because you...
I'm going to object to narrative and non-responsive to the question.
Sustained.
All right. Lastly, do uninformed professionals, in your experience, cops, judges, lawyers, counselors, often fail to recognize the signs of domestic violence?
They do. And sometimes it's because they're not obvious and they're hidden, or they don't understand the dynamic of domestic violence. And they don't necessarily understand that that victim was in fear. And though it may not show, they may be smiling in a photo, or their family or someone doesn't know about it. That doesn't necessarily speak to what was going on.
All right. Now, would you be able to relate these principles to the facts of a domestic violence case with any kind of reliability?
100%.
Have you done that before?
Routinely.
Is that what you in fact do as a professional?
It's one of the major things I do. I might put as a footnote, I'm a therapist. So sometimes clients come to me and I'm helping them with their anxiety and their depression and generalized mental health issues. But many of my clients, because I focus on domestic violence, I'm helping them understand, or the perpetrators, I'm helping them change their attitudes, usually through what I call cognitive behavioral therapy. And I could go on and on.
All right. Could you make that application and its reliability by studying the facts and documents relative to a particular case?
Actually, this is one of my professions.
All right.
I'm hired by the state for cases doing domestic violence assessments, and sometimes I never get to interview some of the parties. Maybe they're not available, they're in prison, etc. in private practice, and also, like I say, through DCF, I've been hired. So I look at the characteristics, what fits, what was there a display of a weapon? Was there all these different things? And
would you be able to do the same application with the same reliability through a series of hypothetical questions?
Certainly.
All right.
And if I can, I would admit that I can't.
Yep. Finally, let's talk about battered spouse syndrome for a moment. Are there any characteristics in traditional battered spouse syndrome that might distinguish it from an otherwise domestic violence abusive situation?
Good question. So basically, the abuse is the same. I think what makes battered spouse syndrome or battered wife syndrome, different terms through the years, different is oftentimes the victim still lives with the abuser, and there can be a history of extreme violence or violence occurring and traumatizing the victim. But the techniques of power and control and compliance and fear and how they hide it and all those things are completely the same.
Thank you very much. I have no further questions.
Cross.
Good afternoon, sir.
Good afternoon.
Have you ever testified as an expert on battered spouse syndrome?
No, I have not.
Do you consider yourself an expert on battered spouse syndrome?
I consider myself an expert on domestic violence, not necessarily the BSS uniquely. I haven't been recognized by a judge in that, doing that. So I think that for me, there's really no difference other than that distinguishing fact, whether they live there or not, or whether there's been physical violence or not. It's still the same dynamic. The victims are the same.
But you could recognize the law might make a distinction between those two things, an expertise in those two things.
Well, I think I'm expert enough to understand that. I just haven't testified uniquely in BSS.
And how did you interview did you speak to Miss Benefield?
I did speak to her.
And for how long?
I spoke to her multiple times with a Zoom call.
Okay, my question was how long? How much time did you spend speaking to her?
It varied a little bit for an hour. Most of the times it was 2 hours.
I need you to add it up. Did you speak to her 1 hour total, 3 hours total?
Oh, total time?
Yes, sir. I'm sorry if my question wasn't clear.
I'm going just by memory. I'd be guessing a little bit here, so I apologize. Could have been I'm just trying to could have been 15 to 20 hours easily.
So you spent 15 to 20 hours speaking to Ms. Benefield?
I did.
Okay. And did you review paperwork in this case?
A lot. That's how I came to my conclusions, uniquely from the paperwork.
When you say uniquely from the paperwork, are you telling this court that you spent 15 to 20 hours with Ms. Benefield, but you didn't base the opinions that you gave previously in a depot on that time?
That's true. I did not do an assessment of her. I was not hired to do an assessment. I did not produce an assessment.
Well, what were you doing for 15 to 20 hours?
Some of it was being a counselor, and some of it was I have a reputation to keep, and I wanted to understand was this really a victim? So kind of got into a routine of understanding some timeline with her about what occurred and how did it fit the facts that I was reading about.
Well, wouldn't that say, if what you just said is you needed to determine if she was a real victim, then it must have come into your decision-making about this case, with that assessment you made. Is that correct?
Could you restate the question,
Well,
please?
you just testified that you spent 15 to 20 hours with Miss Benefield, and part of that was to make an assessment on whether or not she was a real victim. And
No.
so,
Not to make an assessment as I compared the facts that I knew from what I was reading. I wanted some validity, and then some of my time was being empathetic and listening to her.
and
But my conclusions I've come to that I talk about in the deposition were 100% from the discovery. Those were the items, and I could list them for you if you'd like.
did they include the stand your ground motion filed by Mr. Taylor and the defendant?
At the time, that was one of the items. Certainly, if I subtract that from what the things he quotes in the Stand Your Ground were other discovery items. Doug admitting to shooting the gun into the ceiling, him telling that to his priest, and phone calls and texts. So I didn't need the Stand Your Ground paperwork document to find all those bits of information that I found through looking at discovery.
Well, so the portions of the stand your ground about what happened that night were not in discovery. That Mr. Benefield took a bladed stance and did this.
No, I didn't. Those items were not part of my conclusion. I could tell you I have 13 items I use uniquely in discovery that it came to my conclusion on. And it didn't include, and I never spoke to Ms. Benefield about what you just said about bladed stance. I never talked to her about that.
Well, you said you spoke to her to determine if she was I guess to determine her veracity. Is that what you're trying to say?
That's one word, but I never spoke to her about the event of the shooting. Never.
Okay. Did you speak to her about the other things that were in the Stand Your Ground hearing and the discovery from things that had occurred in the past?
I think some of the things did, yes. As I think about, as she's going, basically I did some timeline understanding, when they met up until before the event, and some of those items were in there.
And did you develop an opinion as to whether or not Ms. Benefield was a battered spouse? Like as far as battered spouse syndrome, if you would say that she suffered from battered spouse syndrome.
Yeah, I did not determine that. I determined that she was a victim of domestic violence and that Doug was the perpetrator of that.
Based on
all the discovery and how it fits in with the continuum of power and control and her compliance, her fear, etc.
I don't have anything else, Judge. Thanks. Thank you, sir.
Tell us what you reviewed.
I reviewed a deposition that Doug gave, and I had a written version. He makes admissions. He talks about the gunshot. He talks about punching the dog, throwing the gun, punching holes in the wall. There was a letter to his pastor where Doug admits punching a hole in the wall and shooting the gun in the ceiling. There was a domestic violence injunction in South Carolina prohibiting mutual contact, and the text of that. The really important piece of evidence for me was Ashley wrote a letter on September 18th, 2017, when she separated, outlining domestic violence that Doug did to her. I have a copy of that if you want me to go through the items, but she outlines, without necessarily being a domestic violence counselor at all, she talks, it all fits very discreetly into what power and control and what abused women experience at the hands of their abusers. It was, and also for me, if I might say, that was a frozen moment in time. That wasn't something that she said after I met her or something like that. This was from, 2017.
And were you struck by the terms of basically art that she unwittingly included in that letter as it relates to domestic violence and the power and control continuum?
It was, it's a letter that I can use in training other people to counsel domestic violence victims, or if I was to work with a group of batterers, et cetera. It's classic.
Okay, what else did you review?
Deposition of a neighbor who caught Doug at night in the yard. A text of Doug admitting to putting a tracker on Ashley's car. I mean, these are all items that show ownership, that, stalking sort of items. A text from his ex-wife documenting him physically abusing her on her honeymoon. So this gets into his character, and
I don't know if Nick is not responsive. The question was, what did you review, not his opinion about them.
That's fine. Go ahead. Overruled.
Thank you, Judge. Go ahead.
So here I have all this experience dealing with perpetrators, being a perpetrator to multiple victims. Sometimes when I was a detective, I would, besides my therapy work, and I see that as I interview victims, but quite often my routine, I work day shift. So I come into the department, I go to a detective briefing, I look at cases where the suspect got away. My job was to review probable cause, go make the arrest, or get the warrant. That's what I did. So the first thing I do is I run that perpetrator's name, and I find out there's an injunction, and I'm looking at the charging document that the officer left, and there's no violation of injunction in there. But then I open it up in the court system, and I found it's a different victim. So I found these multiple victims. And also, to be fair, I'd open up her, the female, the victim's information, and I would find that there's an injunction, but it was with a different guy. So there's some serial victims and some serial offenders. So basically, the fact that he is very strong, and I know we talked about it in my deposition with the assistant state attorney, this text message from his ex-wife documenting how he abused her on a honeymoon it was appalling to me, but it was not an unknown probability. And also it spoke to, who am I looking at here? So that was one item. If I could continue. Of course, there was an injunction in Manatee County and some narrative. Dr. Russell, a forensic psychosocial mental health evaluation I read, I think it was April 30th, 2020. She describes the abuse and domestic violence that Doug did against Ashley quite eloquently. It's quite clear the things she discovered in her she did interview and come to that conclusion. So I found that kind of enlightening. There were telephone calls and documentation between Doug and Ashley. I've got a date of August 16th, 2019, where he was, controlling, intimidating, amidst of being outside her house, following her. He was gaslighting her. He pulled a gun on his ex. There was a threat that he was going to kill himself with a gun, and there's more in that without pulling out the document. There was a very significant WhatsApp phone messages between Ashley and Doug, and in that there's statements about being armed, that he talks about warfare, rage, exterminating them, murderous mood, anger to take them out. A warrior side would be, the testosterone rage, talks about killing bad people. So let's say we could say, was this all true? Or was this techniques that to put her in fear of him? Both could be true, actually. I found that very, Dr. Broder, I read his testimony and that he gave, and it was clearly domestic violence was present. There was definitely power and control tactics reviewed by him. The mic blow up, the gun incident was, and I have a quote here, was certainly a frightening experience for Ashley. Doug's temper, yelling, screaming, punching holes in walls. And Mr. Taylor's cross was in that transcript I read. And as you spoke to Dr. Broder, angry temper, very controlling, highly manipulative, very intense. The holes punched in the wall, fired a gun in the ceiling, that, there was an appeasement. That word was even used by Ashley, apparently by Dr. Broder, as a strategy with Doug to protect her child, keep him at bay. This is the very issues I've been talking about. And there was text about him kicking the dog and throwing the cat between Ashley and Doug. So all these elements right here, I got my conclusion from. I didn't need anything else. And this is clearly what I base my determination on.
And would you conclude, based on what you know, that Ashley was an abused woman?
Definitely.
Would you?
And I'm going to interrupt you, Mr. Taylor. Abused woman is to say one thing, but abused woman who was in compliance mode, that didn't want to poke the bear, that was afraid of what might happen if she opposed him. That's what I get here.
And how, if at all, would that explain, for example, Ashley agreeing to go on a parental exchange between Doug Benefield and her daughter Emerson? Ashley, in the week leading up to the shooting, exchanging friendly, lovey-dovey text messages with emojis and things like that. And Ashley at a restaurant with her mother and her child Emerson in the company of Doug, acting happy.
Totally. It's not, doesn't oppose my theory at all, or what I believe was going on. It may be that there's one thing I can say. Ashley did show, from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever, I don't know. But she could put up a good front. And this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. Her getting in that, I guess, you referred to the first visitation.
Yes, at the sheriff's office.
Her going along, that's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson. And so, yeah, that was definitely the mother, the maternal instinct, wanting to protect her daughter, and at her own expense. But that's nothing. I just, I'm a parent. I take a bullet for my kid. It's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm the neutral party here. But in this kind of situation, in a Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I have said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, object. Please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that, Judge.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? When, in my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy of it to verify that that's the complete version.
Sure, you want to see it?
Yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
You don't need it back? Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
No, I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pen markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
Now.
Judge, if I may, it's the defense's burden. My only concern about your asking questions is that they have arrested their witness. And I understand what I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but.
I mean, don't forget there's also the general and proper. So you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
All right, and then you had gone through a list of 13 things that you had reviewed,
Yes, sir.
and I was writing them down as we went, and I'm taking notes. I only got 12.
Okay. So do you want me to briefly?
I don't want the narrative portion.
No,
I just want you to tell me.
Or you tell me. Okay, I'll tell
No,
you.
it's got to be the other one. You have to say
Okay,
to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony. And number 13 was the text, kick dog through cat and between Ashley and Doug.
Can I just ask to clarify, you said phone calls between Ashley and Doug, is that what you said?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
Transcript of phone calls?
I believe so.
No.
All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir, thank you.
Mr. Taylor, do you have any questions based on my questions?
No, Your Honor.
All right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay,
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
okay,
So stay in touch.
okay. And so I'm still under my subpoena.
Yes, sir.
Thank you. I do appreciate your attention.
Absolutely. Have a great weekend. Don't forget you've also got your wheel over here. Or is that yours?
That's theirs.
Okay.
I've got mine. Thank you. Thank you.
Sir. Safe travels back home.
Yes, appreciate it.
Well, we're looking to go right at the perfect time, aren't we?
Yeah.
I want to stop and have dinner.
Or pack up my hotel room and put my blue jeans back on, right?
Yes, sir.
Thank you.
All right, the witness has left the courtroom. Did you have any other witnesses' testimony or evidence you wanted to put on for the Daubert hearing?
No, sir.
State? Did you have any evidence, testimony you want to put on?
No, sir, thank you.
All right, I'm ready for argument.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows, provides if scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the three requirements, sufficient, if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and three, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to the shooting. And included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But, as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under Duluth Power and Control Wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try.
Please don't get behind me. I'm sorry.
Why she would try to get along, go along. So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the second DCA.
Oquendo.
Yes. No, this is Wyand. Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999. The Supreme Court rejected the second DCA's position in the Wyand case and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, Implications for Victims of Domestic Violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyand help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyand goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind to the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far. with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Miss Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Miss Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We were trying to meet it. That's our position.
All right, thank you. State?
Thank you, Judge, I'm going to try to bring it back to Daubert, but I do want to address Akendo because it frames my arguments. Sorry. Under the Okendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Okendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome, and part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Whelan case also defines battered spouse syndrome. It says,
You want to spell it?
Sorry, it's the case Mr.
Wyand?
I'm sorry, Wyand.
Whatever, however you want to say it. I see no
I
which
don't,
one.
WEIAND, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel that leaving
do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important and the state asked it is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits he does, that's not what he was doing. There's only two options for that, and your Honor's aware of that. That one, if she's evaluated, then they have to file notice and we are allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional, apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a product. I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome.
No,
they have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder. And it certainly goes to her depraved mind. But the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert, scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard.
I don't agree,
Thank you.
of course.
Rebuttal?
Yeah. Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court drawing a distinction between Daubert and the case law on battered spouse syndrome. I would suggest that, given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome, because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomenon. I think I need and I should be entitled to be able to explain that to the jurors. And I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with the case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote.
Mm-hmm.
And the reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those two elements. I shouldn't even say it requires those two elements. Those two elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence, because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was to battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about, diminished capacity, right? Essentially diminished capacity, because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
All right. Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that it would take in order for the weapon to fire? And you call an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case.
I do not have a specific case on that point, no.
Well, she doesn't allow him to testify.
And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned, if it came in under battered spouse, to follow the Heenum option, whereby he would be given a series of hypotheticals based upon facts and evidence.
Excellent segue. That was my next question. I didn't keep track on the clock how long Mr. Ferris testified about the general properties of domestic violence, the Duluth wheel, the cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes.
Moving on.
So if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan, if he comes in under the Heenum approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception. Or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenum approach or under just domestic violence expert. The state as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that way. You're doing hypotheticals. He's not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in, yeah, under battered spouse syndrome. That's correct, Judge. I would follow the Heenum approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson. I'll get it for you.
So then, I know it's not.
It's,
I was like, I heard us that when they allow it, once split up.
That noise. He allows it in. It's going to be with a lot of restrictions. Good Lord, people.
Jack, do you remember which was it? Yeah, it is in Hickson, but the case is Heenum.
My question is this. He spent so much time on these Hornbook issues, and the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented, so I could even hear him and consider him and listen and see if he applied the principles reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypotheticals?
Well, hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold and I asked him, could you reliably apply these principles to a series of hypothetical questions if asked? He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would ask the hypotheticals, Your Honor, based on what we know is record evidence. For example.
Exactly. What's in the record, what's been admitted.
Correct. But
is it your position that all 13 of those items have been admitted into evidence?
No.
So I would need to hear the hypotheticals to know what you're going to ask about.
Okay, so I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting that show emojis and friendly banter back and forth. Would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses, so there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful.
Hold on.
Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
Thank you, sir. All right, State.
Judge, I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this battered spouse syndrome case or not? I would argue that it is not, that there's been no showing that battered spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record, because clearly he got a lot of things that are not in the record. That's it, thank you for letting me be heard.
Just checking.
Okay, anything else we need to take care of before I let you go?
Nope.
When do you plan on calling Mr. Ferris?
Like to call him first out Monday morning.
Okay.
Do you think it'll be a roll over the weekend for Monday? Is there anything, I did have one question, is there anything in here Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Okay, thank you, sir.
So does that mean you can call him? Or not?
Make sure that one's turned off. It'll run it back.
Thank you for having me here and for making it a long day, but thank you.
I guess he dismissed them. Yep, I guess so. Okay. I guess we'll find out Monday. I guess we'll find out Monday. This case has gotten very confusing. It was a lot of pro-offers for the afternoon. The state, when they crossed Ashley, was brutal, condescending, malicious, traumatic, not only for Ashley, but for me as well. And I may have to put a trigger warning. I will put a trigger warning in the description for anybody who has experienced any form of abuse and domestic violence. Whew. Oh, brutal, absolutely brutal. Okay. So Monday will be day 5. And we'll see what happens then. So enjoy your weekend. Relax, do something out in nature. Get rid of the negative and pull in positive, however you do it. If I was a drinking person, I'd go off and have something to drink. Anyway, we'll leave it here for now. Do what you got to do to take care of yourself. And hopefully we'll see you back here on Monday. So until then, take care and God bless.